Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault. And you're charged with theft of a firearm worth less than $2,500.
Procedural matters. Unfortunately, you have not.
Is not
You are a grand jury.
Hello and welcome to the Court of Public Opinion.
Hello.
I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He's roughing him up quite a bit.
Procedural matters.
There's a lawsuit.
9 out of 10 judges for watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the table. Dati mihi Anglican, praise Verbus Latina. I didn't ask you to interrupt me.
Is that correct?
literally not true.
Oh, from say.
Good morning, welcome to the Court of... I should almost say good afternoon. I should almost say good afternoon. I'm sorry it's a late start. It's a Monday for me. Oh, man. Hope you all had a wonderful weekend. I did. My son's here. He's back home from college for the summer.
Hello.
So that's been exciting. All right. Good morning. How is everybody?
In front of the Walmart.
Good morning from Iowa. Deb, thank you very much. I have to give a special shout out, first of all, to AJ Red Sox. AJ, I'm not sure if this is the first time. I think it's the first time for you. So you might have sinned in ignorance, as they say. The first person in chat who breaks the stillness of the morning, who is prompt and punctual and says something like nice, like hi, like you did here. Yeah, he's broken the curse of the babe. The first person in chat is always punished. And I'm sorry. I realize you're completely caught off guard. You had no idea. You didn't want to be in the situation, but ignorance is no excuse when it comes to the law, and we are going to punish you. Everything IP related worldwide is your responsibility. That's right. I am sentencing you to be internet owner for the day, or at least until we go live again this afternoon. We're going to be going to a couple fun places like Judge Dad, who's working today. Look at that. I'm so excited. Well, we'll be back, Judge Dad. Just wait, hold it. Wait for us. Let's see. There we go. Pause, Judge Dad. Anyway, congratulations, AJ Red Sox. This is going on your permanent record. If you would like to have an official notice of this violation, you can go to our shopping tab on the YouTube channel page. And if you browse around long enough, either by accident or by on purpose, you can find the downloadable digital copy of your internet ownership certificate, which is already pre-signed by myself and my boss, Mrs. R.A. That certificate is suitable for framing or as use as a cover sheet on your CV. So help yourself to that. It is like fill in the blank, though. You have to write your name on it. You downloaded your certificate. Wonderful, just Stephanie. It's awesome. Once you qualify, you're eligible. And it's for the low fine of 50 cents. I mean, you're never going to get punished in a law-type setting, and I say type loosely, and have a lower fee than 50 cents. So, lowest fees in the internet. All right. Welcome, Mimi D1, a member for 35 months. Congratulations. Says, woohoo, love it here. OG. You are, in fact, an OG. All right. Let's see. What's everyone talking about this morning? Paula has a red rummer for a neighbor. Paula? Who wants to go down the rabbit hole with just Stephanie and me? Look up Mo versus Rebecca Rudd. Just found out she's my neighbor. Oh, my goodness. Lock your doors. Hide your kids. Hide your wife, because they red rumming everybody around here. All right. Good morning. Let's do the morning things, shall we? Wow. How's your pain? My pain is doing well. Well, it depends if it's actually feeling much better.
Happy birthday. You look good.
Do you know what helped? I went and I drove to Wilson, 47 minutes away from me. I drove to Wilson, North Carolina, thriving little metropolis. No, it's a tiny, small town. Most famous for its elaborate windmills. made out of road signs. It has a whole park dedicated to them. They're amazing. It's worth the trip. But I went there and I went to another park and we picked up some trash as part of a youth service project. Picked up like, I don't know, almost like 700 pounds of trash. It was tons. And then I played Frisbee with my hurt arm for 2 hours. And now it hurts in other places so much that I can't feel the original pain. So I think it's better. Love my grandkids. I think it's better. I'm just so sore from throwing the Frisbee. Yes, we do have new trials coming up in the future. One of them is about a week and a half away. On the 28th is the start. Red Pen, thanks for coming in with the birthdays this morning, by the way. Shout out to our amazing mods. Red Pen, one of them. Buffer, happy birthday to Jay Norman.
You look good.
Thank you, Judge Fleischer. Heavenly birthday there. And Sewing Mama. So we're going to sing happy birthday to Jay Norman and Heavenly Mama. And by we, I mean all of us. That means me and you, wherever you are. If it's legal and you're able, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. There we go. Happy birthday to you. Happy birthday to you. Happy birthday to Jay Norman and Sewing Mama. Happy birthday to you. And apparently Thomas Jefferson was also born on this day many, many years ago. So I guess that would qualify as a heavenly birthday as well. Red Pen, happy birthday, Thomas Jefferson. One of the forefathers, one of the founders of this great fourscore. No, that's somebody else. That was Lincoln. Jefferson wrote the papers, right? What's that, Madison? Forget. I haven't watched the musical in a long time. I don't remember my history. Nobody put him on the form. Do we miss any birthdays? Are we all good? I think we're good. To everyone who celebrated their birthday today, happy birthday. There are many wonderful days, but today's your special day. And I realize there are a million places you could have been, and a million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is ours. Hopefully we can return that joy back to you, make your day just a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. And now we get to sing to Donna, who had a birthday on Sunday. Thank you, Red Pen. Appreciate it. Greeners, good catch. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Donna. Happy birthday to you. And then drum solo. Oh, wait, not yet. One more verse and then the drum solo. All right. Donna, help yourself to the free pancakes. The dancing is for you as well. Looks like it's hot and ready right now. Now drum solo. Good job, everybody. Maybe if Red Pen weren't up all night watching the screw stream, she'd be more rested. I didn't know you guys were calling it the screw stream. I did a live stream on Friday afternoon, where I had to assemble a great deal of, a good number, let's say that, a good number of components for a mobile live streaming kit. And yes, it did involve a screwdriver, which I used a hammer drill for because I only have like two tools, and a hammer drill is one of them. And Bev, I have been practicing this song for so long. Apparently, there were a lot of screws. And it became the screw stream. My fingers still hurt from trying to hold the little, the screw goes in one end and the nut goes on the other to tighten down and hold something in place. I was trying to hold that little tiny nut. Well, using the high-speed drill on the other side. And of course, it would tighten down and then just spin on the back end. And so my fingertips are bruised from this. They should make a tool. They should make a tool that fits over that little nut so you can hold it a little better. My brother wants to know what model your live streaming thing is. Mobile one. Katrina. The mobile one, this is going to get a little techie. It's a 6-unit rack. That means it could hold 6 different, well, it's got room for 6 different 1-unit slots. 19 inches wide. The top is an ATEM Constellation 4K with 2 ME. That means 2 mix effects. I can do a lot of things with it. It's like having 2 switchers in one. That's the top. Below that, I have a 3-unit dual 8-inch LCD monitors, so I can watch 2 screens at once. Below that, I have a 4K HyperDeck recorder, so I can record in 4K to SD cards or an external hard drive or something like that. And I also, on that same rack, I have a 4K streaming encoder, all of these from Blackmagic Design. And then below that, I have a 1U power supply, which runs the whole thing. On the back, I've now installed my cooling fans in the top rack, which have a temperature probe inside. So when it gets above a certain degree, it cranks the fan up and blows the hot air out the top. I have my racks of plugs, so I can plug everything in and not have to reach in and connect to the back of the machine. So all the cords sort of go to the back, and I can just open it up and pop something on. And I also have a internet router, which assigns DCHP, DHCP, Dynamic Host Control Protocol, internet addresses to all the devices. And then it also provides that through an 8-port Power over Ethernet Netgear switch, which can power remote cameras, switch, controllers, things like that. And everything in there is connected through the network. So I can plug in one plug and access everything over the Ethernet. I think that's all I have. Let's see. Oh, and I also have one a 12G Blackmagic Design bidirectional SDI to HDMI converter, so that I can plug in an HDMI plug and have it on my switcher, or I can send the SDI to HDMI, either way. All right, Spoopy says, is this a tech channel? I just thought I was watching for court. Yeah, but you asked a tech question, and that's where I get distracted. It's like, squirrel. So, Greeners, this is not so. This is not so. Let me just show you. I'm gonna show Greeners. Hang on.
Squirrel.
Okay, now I lost it. I don't know where it went. Oh, it's right here. This is going to be a little bit confusing because it's like Inception, right? Where you've got like nested picture inside a picture. Okay, Greeners, peek behind the curtain. This is what I see when I live stream. Right here is when I started talking tech. Boom, 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 boom. Booyah. Booyah. What more do you need to know? What more do you need to see? So anyway, you don't need to see that. That's on my end. All right. Let's see. Katrina Bunny, show him that part. Yeah, if he has any questions. Honestly, have him reach out on my burner phone. He's got some questions. I've had a couple people reach out about things they want to do on their channel and live stream and ask some questions about how I do it. I'm all about sharing. This info is not going to do any good if I just die with it in my head, so I need to tell it to somebody, and be happy to help somebody out if it does. If not, we can just shoot the breeze. All right, Blackmagic Design better sponsor this. Please. Oh my goodness, I cannot afford this if they don't sponsor it soon. I basically have everything they already produce. I've got everything. So there's one more pinks. there's one more thing though. We're working on a mobile setup, but sometimes you guys are at the place where I want to be, and I would love to see what you guys see. And so there's one more component I need to bring into my setup that will allow anyone, wherever they are, to open up a free app on their iPhone or Android. And it's a camera app, but it's not the normal camera app. It's by Blackmagic Design, of course. And it would connect you directly to my switcher so that I could literally just take your camera like we take a court camera and bring you in just as a remote guest instantly in 4K. So there's an app. We'll get to that. I don't want to have everyone download it because honestly, only a few of you would be using it, and it would require a little bit of configuration. So I would send you a little link that you would copy and paste, and it would route to my computer. But for those that do want to be on site and share views, we're going to have an option for that from anywhere in the world. So, all right. Where are we? We were going to go to court, right? Judge Dad is starting, and we put him on hold. We're going to go to Judge Dad here first because he's walking in again right now.
He's seated.
We're seated already, Judge. We were waiting for you. We're good. Good morning, by the way.
Is Granite Televalley in here yet?
Granite Televalley?
People against Andrew Joseph Ellis, Webb, 26B82402A.
People.
Good morning, Judge. Nice to
versus-
get the Webb, the rest of the full name. Andrew Webb.
Alicia, our thoughts and prayers with you. Good luck. Good
I
luck.
don't even want to make an excuse. I wrote on my calendar the 18th, totally made a mistake. I realized at 5 o'clock on the 8th. It was actually my birthday as well. About 5 o'clock, I got done working, realized it was the day. I had a real early pour in the morning. Thursday couldn't make it. Came Friday, but couldn't see it.
He missed court. He's doing concrete work. That's hard work, Judge.
Heather, I want to make sure the victim didn't well, I'm going to have to do this over. Reschedule sentencing. Notify victim. I don't remember enough about this one, but I would have read the police report that day. But there was an order on here for me to forfeit your bond. I'll give you April 22nd, 8:30.
Okay.
Take the notice,
Okay.
tape it to your refrigerator.
I want to apologize again. I'm very
All
sorry.
right, good. You don't have to grovel. April 22nd, 8:30.
All right.
I'll see you back here then. Good luck.
Thank you.
You had another misdemeanor, right, Mr. Gabe?
I'm sorry.
Didn't you have another misdemeanor?
Yes, it was,
Okay, I'll take that
I
one.
believe, Mr. Hayner.
All the judges are working right now. Everybody's up. It's crazy.
People against? Gary Allen Hayner, 23B, 1433588 and B. Yeah.
Well, can I get the parent back, Mr. Hayner, Mr. Hayner, state your full name? Gary Hayner.
All right, so what is he going to do?
Judge, he'll plead guilty to the failure to comply. He was sentenced on this case back in 2023, Judge. Mr. Hayner was having some personal problems, plus some financial issues. His main issue was financial. His children's mother had suffered an injury at work. And
All right, let me just take the plea first and then we'll go from there. Okay, and you can allocute then, okay?
Sure.
So, sir, you have a disorderly person, public intox. You have a resist and obstruct an officer. I sentenced you on these back on August the 2nd of 23. You were then supposed to be here for a show cause because you failed to enroll in on-site testing. And you were supposed to be there and enroll on August 4th. We set a show cause. You didn't show up for that on August 22nd. So that is the charge. Failure to enroll in biweekly chemical testing is ordered on August the 4th of 23. Do you understand the charge?
Yes, sir.
If you plead guilty, excuse me, or if you are found guilty, I do want you to understand this is a non-technical violation here since you did not show up. You've absconded for more than 90 days. So you could get, or for more than 60 days, I should say, I apologize. And you could have your probation revoked and you could get 90 days on each of these charges. Do you understand that?
Yes, sir.
All right, did you sign, read, and understand and advice of rights being here today?
Yes, I did.
I don't know that it's not. Did you sign a double sheet certs that you believe that I mentioned this? No.
Sloth Life, I am so sorry. Get some rest, get feeling better. Let us know if there's anything we can do for you.
Judge, we just have a minute. Let me explain.
Sure. Take your time. We'll go off the record.
Off the record. Take your time, take your time. Hey, Barb, these are all real trials. We don't watch any fake ones. Just some of the trials have a lot of proceedings and hearings, and some end before they ever get to trial. This is all just part of the process.
John, call up Beth. Tell her we're going to need somebody on this case.
Okay.
Hayner.
Simply Nikki, member
It
for
was
14
Emily's.
months. Sloth Life, by the way. I know you don't want to do the normal jump and cheer, but
Gary Hayner,
27 months as an attorney.
Gary Hayner.
But this is not the way to celebrate. With the broken elbow and the bust lip and cut nose and scraped black and blue purple knees. Here's what I say. I'm going to have to put my foot down on this, Sloth Life. No more rollerblading. No more skateboarding. You have got to step it down just a notch. We need you around here in good shape. You're going to have to, I know you were good at it.
Yeah.
I know you like doing the tricks and the spins and the kick flips and all the ollies and the front side 360s.
Right. So, sir,
I need you to dial it back a bit.
Mr. Hayner, have you now had a chance to review the advice of rights? Did you sign it?
Yes.
Did you understand it?
Yes.
Did you go over it with your lawyer?
Yes.
If you plead guilty here, you're going to be giving up all these rights, and we're not going to have a hearing of any kind. Do you understand that? All right. And you understand you could, since you've absconded, this would be a first non-technical violation.
Absconded?
Since you absconded, you could get 90 days on each of these files. Do you understand that?
Yes, sir.
All right.
He doesn't like
You
that.
still wish to plead guilty
Yes.
to the charge that you failed to enroll in biweekly testing by August 4th of 23. How do you plead?
Guilty.
Did you fail to enroll in biweekly testing by that date?
Yes, sir.
And you were told by the probation officer to enroll, true?
Yes, sir.
And you failed to do so? You just absconded then, right? This was the day after the sentence and you decided you weren't going to do anything?
Yeah,
Is that, I just want to know, is that true?
Correct. I was captured and I didn't have a license. I didn't have anybody, like any family support, so I was kind of like tied by the seat of my pants. So maybe, yeah, like I didn't have a way to do.
Anybody force you to plead guilty?
No, sir.
All right, I'm going to accept your pleas. Now, what would you like to say, Mr. Gay?
Judge, just that, like I mentioned earlier, it was an issue of finances at the beginning. He did not have a valid license. He didn't have a stable place to stay because he couldn't afford to pay rent. majority of his money was going to help the mother of his children, but suffered a back injury at work. So in addition to having to pay her child support, he was also picking up some of the additional expenses for the household. And because he does share two children with her, 15 and 16, I believe, is that correct?
Yes.
And so at the time, not only was he unable to come and go, even if he had a job, Judge, but any money that he did have went to trying to help keep that household in place and keep them at least somewhat solvent at this point, because there was no money coming in on either side. Judge, he did walk in on his own, so I'd like the court to consider that. And he is able to pay the entire amount of the balance due today, Judge. He is also, since then, he's had no run-ins with law enforcement whatsoever. He's trying to resolve all of his outstanding issues, Judge. He's full-time employed at B&D Cold-Headed Products in Wayne City. He's been employed since
Full-headed products.
2018 with just some gaps in between that, and what that wasn't steady employment. One of the gaps would have been right around the time that he caught this case as well, Judge.
Did they sell like
But now he's back to
mullet
full-time
care
employment.
products?
He does work the night shift, so he's able to clear as far as any balances due. And
Ozzy
that
Gardner,
would take that
whoa.
into consideration, Judge. You can correct me.
Where are you working now?
Work at B&D, drug roller, B&D Cold-Headed Products, it's off of Van Born and Wayne, Van Born Road in Wayne.
In Wayne City.
Yeah, it's outside right.
Clouds?
Elizabeth Patient, Your Honor.
Anything at all?
I was just reviewing the file, Your Honor. We didn't get to notice the warrant recall. It looks like Miss Tessino, who was supervising him at the time, met with him, got him instructed, and then essentially absconded right after that. The only thing I would have to go back in my office and check on is see, not sure if it was mentioned, if he did any of his court work program days. He was scheduled, but I would have to look at those sign-in sheets in my office, Your Honor. But other than that, again, there is no verification of treatment, 12-step meetings. The test that the violation was issued for was his initial test with on-site. So it looks like from the beginning he absconded, Your Honor.
Right.
Judge, I don't believe, by my discussions with Mr. Hayner, I don't believe that he's done any of these.
No, it was, I sentenced him on August the 2nd, and
he did nothing?
he didn't enroll by the 4th. And that's when he just left. He just decided, for whatever reason, I don't care if it's didn't have a ride. You just can't do this.
I did turn myself in other cases. I was in, did some time around that, right around this time too. I was in Wayne County and had probation for them to district court since, for 2 years now.
Out of the Third Circuit Court, you mean?
Yes, yeah.
Right.
For
Because you had a felony.
the child support, Judge.
Yeah, and I took care, I had stuff in enroll, I went and took care of, turned myself in, and I had a bunch of other deals I was taking care of too, and this, I don't know, it gets a lot on my plate. Doing the best I can, I'm trying to take care of it now. I'm doing the best I have done.
I think the best you can do
I
needs
do
to be a
have a
little
screen,
better.
Judge, if you can see it.
Please. I mean, I see why I did what I did.
A lot of mistakes there, so I'm trying not to only throw to me.
I think Judge Dad might have fallen over the weekend and also got a scraped up nose.
How much is old? Can you tell me?
276.
983 and 276. So he has $1,214 on, right?
You can pay that today. I can pay 900 today. That's when we made the phone call. I went to the probably give him 12. Was it an infraction? Was it 880?
The file said 840 at the time.
We just can't do this. Probation's revoked. You're on the disorderly person charge. You to pay costs of 900 and serve 90 days, credit 1 for 89. If you pay 900, I'll suspend 59 of the 89. You'll only have to serve 30. On the R&O charge, same thing. Probation's revoked. You're to pay costs of 200 and serve 90 days, credit 1 for 89. If you pay 200, I'll suspend 59 of the 89. You'll have to only serves 30. So you have to give them $1,100. You have 21 days to appeal. Here you go, Ayden. 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you well. They'll let you make a call. Just can't. It's good luck. Thank you. Here you go, Amy. Granite Televalley versus Ronald Allen Bodges, 260001. Come on up here, ma'am. Good morning, Mr. Landman. Your appearance.
Good morning, Your Honor. For the record, Daniel Landman, P35797, appearing on behalf of the plaintiff.
Mr. Bodges' sister is shown up here. I'm not sure why. I'm going to at least ask her to identify herself. Come on up to the podium.
Oh.
That's the podium there. Your name?
Michelle Bogus.
Where is he?
He is in the hospital. I went up to the desk and gave them paperwork from the doctor. Went through the emergency room. He is going along rehab. So all his rent is all paid up. There's a copy of that there as well. With her signing off on it and the receipts.
So, Mr. Landman, this is the one I was a little curious about. They started not only the termination action, but a non-payment action. If you'll bear with me, I think this is what happened is I stayed this case because this has to do with failure to comply with community rules. And he's charged with felonious assault. So I didn't per se stay it, but what I said is I don't think it's fair. He's got a felony pending, and I'm not going to have somebody in a civil case without a lawyer incriminate themselves. But in the meantime, your office did a non-payment rent case. I'm pretty sure, don't quote me, when I get rid of a case, I forget about it. But I'm pretty sure, unless your records will reveal differently, that I gave you guys a judgment with a writ date. And it sounds like Mr. Bodges has paid that now. You heard what his sister just said. I'm sorry, ma'am. Your first name again?
Michelle.
Michelle. So my inclination here is for us to double check on that. Jennifer, are you out there? Yeah, would you do me a
Your
favor?
Honor, the property manager is present and raising her hand, so she may be able to give us some insight too.
Okay, thank you. Wait 1 second, Ms. Bryant. Jennifer, would you check on that? I'm pretty certain that I'm right on that. Ms. Bryant, you can unmute and tell me your name.
Suzanne Bryant for Granite Televalley. Yes.
Is my recollection correct?
Right. He had a writ date of the 8th and he paid by the 8th. So it was all taken care of.
I don't think I can proceed on this termination action anyways. I mean, I don't think I can do that if it's solely on the basis of committing an assault on another resident. I don't feel comfortable with it. I got a guy here that's charged with a 4-year felony, and if he did it, I don't have any remorse for him, but I still have something to do here and that is to protect people's rights, and I can't imagine me forcing somebody to go through with the hearing. So I can do one of two things for you. I can adjourn this again, but I'm not going to set a hearing date until there's a resolution of the felonious assault case in circuit court. So I'm inquiring whether or not you may be willing to dismiss this and refile when that issue is resolved. Ms. Bryant, you had your hand up again. I can't change my mind on this. I want you to understand I won't. But go ahead. What do you want to say?
Your Honor, if I may, before Ms. Bryant, firstly, which hospital is he in right now?
He's in the Heritage Hospital on Telegraph Road. When I came in, I went to the desk and they have all the paperwork that's notarized, signed by the doctors, all the receipts.
Who has it?
Pardon me?
Did you go to Heritage or did you bring the paperwork here?
I took the white flag. Then I came here.
I know. Where's the paperwork?
Yeah,
Your Honor, it should be in your file. We did bring down a copy.
Yeah.
Oh.
I brought them.
So it just said he's admitted on April 12th and will remain inpatient until medically cleared.
Yes.
So did you want to say something else?
Your Honor, I do need to make a record on this.
And you're going to say
as the court is aware, the standard in this particular case is a civil standard, which is weighing the evidence. The problem the concern that I have is I have a history, not with this particular individual, but in a different court, in a different case with a similar situation, that being a tenant that was charged with an assaultive crime. There was a delay of approximately 3 years from the date of the offense until the termination case was actually heard.
The same reason that I'm mentioning, though, right?
But under no circumstances is my client going to dismiss the case and then turn around and have to file a new 30-day notice whenever these other proceedings are concluded. My recollection is that in this case, there may also be a competency situation. And the last thing I want to see is this case delayed while we're waiting for the defendant to be competent to stand trial in the criminal case.
What do you want me to do, Mr. Landman? Tell me what you want me to do. I can't proceed.
There's I see two possibilities, Your Honor. Well, 3 possibilities. What we would prefer, obviously, is for a trial date to be scheduled. That not being an option, then there's 2 ways to go. We could do a conditional dismissal with the tenant agreeing to move out by a date certain. We're not able to do that today, obviously, because he's not here. The other option is to, again, adjourn and get a new date. And if the tenant is willing to vacate, we can get a conditional dismissal in before that date.
It doesn't, well, he's got to agree to a conditional dismissal,
You would,
right?
yes, that's correct. And obviously you can't do it today because he's not here.
There is no way I can go ahead and proceed with the trial on this. I just am not comfortable with that. I'm not even sure. I don't believe now I could be wrong. He just paid the money on a non-payment case. That signifies an intent that he has no intention of leaving.
Well, he's also required by statute to keep his rent current while the termination case is pending. And that's 600 point, MCLA 600.5779.
I get all that, but that tells me he doesn't want to leave. Right? I mean, if he wanted to leave, he would have not paid his rent and just left, right? So I'm pretty confident when he comes back here next time, he's going to tell us that he doesn't want to leave. I am not going forward with a trial on this without a resolution of the Wayne County Circuit Court action first. I'm just not comfortable with it. There's no way I'm doing that. That's not fair for me to do that. He might be not the best person in the country, but you know what? He has rights, and I'm not going to violate them. So what am I supposed to do? Keep a landlord-tenant action open, like you say, for 8 months? I mean, I guess the Supreme Court is going to come down on me thinking I'm fooling around down here, but that isn't the case. And I can't enter a stay of this and have the time guidelines stop running, or I would. So I'm not quite sure what the answer is, but
I think he has a trial date. Currently, there's a trial date, I believe, in July, but I don't know what the competency ruling of the decision is going to be between now and then.
And that's probably going to get delayed because the competency exam staying everything else essentially. They're not pre-trying it. They're waiting for the report. I'll adjourn this 2 weeks to April the 27th. Jennifer, is that right?
That is correct, Your Honor.
At what time? 8:30?
No, let's do 9:30, please.
Okay. 9:30. I'm just asking you guys to put yourselves in my position here. I would waive any filing fee. Obviously, if you agree to dismiss this, I can't do anything about the 30-day notice, although maybe I can figure out something. At any rate, you guys come back, and I'll see you on April 27th on that one, okay?
And Your Honor, in the meantime, if the court can, I don't know if the court has any information that's available to the court and obviously not available to me with respect to the status of the competency evaluation. I'm assuming that this gentleman has counsel in the criminal case, perhaps court appointed, but I would also expect that that case is at least moving forward to some degree, and that a competency evaluation would have taken place or would be scheduled rather than the case just sitting fallow.
No, I think the problem with the competency exams, I don't think you do a lot of criminal. The problem with those is that they get scheduled, especially for somebody who's not in custody, a couple months down the road. And that's always the difficulty there. Now, he told me, I think it was just one of the last couple of times that the competency exam had been ordered. So maybe there was a delay in doing that. And
Your Honor, Ms. Bryant has contributed and indicates that there is a competency exam scheduled for May 23rd.
Right.
So maybe April 27th is not a great date to put this out. Maybe we put this out until after the competency exam.
Competency exam, by the time they get the report, it's going to be June the 10th. I want to think about this. I'm going to still keep it on for April 27th. You'll have other ones that day. I might dismiss this on my own. I don't know how I'm going to handle it. I'll think it through. Good luck. I mean, I can't do that really, but maybe I can come up with something that's creative. Have a good day. That's what I'm doing. Thank you. Granite versus Seth Lawrence Bremer and Sibel Jane Justice, 2601459.
Daniel Landman, Your Honor, on behalf of Tele-Valley.
Do I have any?
No, Mr. Bremer and Ms. Justice did not appear with me, Your Honor.
And you paid for a second mailing. This was a first appearance. You can go ahead with a default.
Thank you, Your Honor. Plaintiff does respectfully move for the entry of a default judgment for possession.
Granted.
Rent to retain, Your Honor, is total of $1,569.48, made up of $1,499.48 in rent and $70 in late fees, representing 2 months at $35 a month. Filing and service fees are $176.07, and the statutory attorney fee is $75, and that adds up to a grand total of $1,820.55. We'd request a writ date of April 23rd.
Defendant failed to appear. Writ date will be April the 23rd. The amount to be paid to save it from the issuance written, the judgment amount is $1820.55. Granite versus Tammy Charity Deronda Siggers and Joshelle Sky Gerwatowski, 2601460. Are any of those individuals here, Jennifer?
Your Honor, they did not check in with us.
Paid for a second mailing. You can take a default on this one.
Thank you, Your Honor. Based on my client's books and records, total rent to retain is $1,554.59. That consists of rent of $1,484.59 and 2 late fees of $35 each for a total of $70. Filing and service fees are $176.07, and the statutory attorney fee is $75, resulting in a total of $1,805.66. And again, we request a writ date of April 23rd.
Defendants failed to appear. The relief request will be granted. That is a default judgment of possession in favor of plaintiff and against defendants. The writ date in this case would be the 23rd of April, 1805.66 is the amount to be paid to save it. Granite versus Paris.
Selena, 36 months as an attorney.
And Angelica Marcia McGee, 2601462. Okay, Mr. McGee, I need to see you better like that, sir.
Mr. McGee or Mr. Magoo?
You're not in a moving car, right? No, you wouldn't do that, right?
No.
What's your name?
Oris McGee Jr.
Where are
Oris
you?
McGee Jr. I'm parked in my car. I'm at work, but they've given me leeway.
Where's Angelica McGee at?
She's actually at work. She wasn't able to appear with me today, but I'm representing both of us. That's my wife.
You can't do that, though. I'm just telling you, she's going to be defaulted. She's got to show up. First of all, did you listen to and understand the rights?
Yes.
And do you wish to speak to a lawyer?
Yes.
If possible, like to speak with the landlord, we could possibly settle something.
I can let you do that, but I'm asking, do you want to speak to a lawyer, and do you intend to apply for funding?
No lawyers needed.
Selena, we're so proud of you. Funding. That's awesome.
No, not at this moment, no.
Why don't you give me the total amount, Mr. Landman, please, that's due?
Absolutely, Your Honor. Without giving the breakdown, based on my client's books and records, there is a total of $1,884.85.
You agree that you owe that amount, Mr. McGee?
Yes.
And when can you pay that by the 23rd?
Let's see. I can pay about 800 of that today. Actually, I can pay 1,000 of that today, and the remaining amount I have to see. I get paid bi-weekly, so I'm just trying to make sure I got this correct.
What day do you get paid?
I'm checking now.
Tell me, is it Mondays, Fridays? What is it?
Fridays.
So you got paid last Friday?
Yes.
So that was the 10th. So you're going to get paid on the 24th. How about if I do this? Mr. Landman, any objection? Here's what I can do. I could enter this judgment for $1,884.85, and I can say if defendant pays $1,000 by April 23rd, writ date extended until the 27th. Is that acceptable, Mr. Landman?
Ms. Bryant, what do you think? She's nodding.
Yeah.
Yes. Okay, so you want to do that, sir?
Yes, that works.
So I'll do that after a hearing today. I'll enter a default against your wife. That is your wife, correct?
That's correct.
Judgment after hearing versus you. if defendant pays, and the total amount is $1884.85, and if you pay that as follows, $1,000, no later than the 23rd, I'll give you until the 27th to pay the balance. Fair?
Yes, that's fair. Thank you.
All right, so we'll do that. You can submit the order, Mr. Landman, and you don't have to, we're not going to do it as consent or anything. That's after hearing, okay?
Very well, Your Honor.
Any questions, Mr. McGee?
Not at this moment, no.
I wish
Thank
you
you, Your Honor.
well. Thank you. Good luck. Granite Televalley versus Timothy Scott Stevens, 2601465.
Your Honor, he did not appear with us.
All right, so that you got a second mailing on this, you can take a default.
Thank you, Your Honor. Based on my client's books and records, there's total rent to retain of $825.30. That consists of rent of $790.30 and one late fee of $35. Costs are $116.36, and there's a statutory attorney fee of $75. We're requesting judgment in the total amount of $1,016.66.
Let's jump to Judge
with a writ date
Boyd.
of April 23rd.
Judge Boyd in
failed
Texas.
to appear. The relief request will be granted. That is default.
There we go. Judge Boyd is having a day as well. Looks like she has a few. Well, she's got a new purse for sure. Judge, you're muted. Yep, she's muted. She's got a new purse. Maybe some new flowers back there. A couple Eastery spreads. There's a lady at our church that gave my daughter a purse over the weekend. And apparently we're bad parents because we hadn't really got her a purse. But she's going to be a teenager soon. And she wanted a purse. And so we were going to get one, but this lady gave her one and said she's like over the moon. She has got that thing cram-packed full of like all the essentials. And by the essentials, I mean probably like 7 different fingernail polishes and a book she's reading and a hairbrush. And, I mean, it's got like pockets and everything. Lip gloss is in there. When daddy's gone buying cables and gear, we can get you a purse. That's basically how it is. New week, new purse. Anyway, I didn't realize how important the purse was, but now we know. All right, Judge Boyd, looks like she's just sitting tight waiting for court to kick off. She has a full courtroom there. Looks like her docket's probably quite full. Liking the flowers. Do need the purse ID'd. If somebody can quickly tell me if that's a DMV purse or... Let's see, I'll do a quick capture. Reverse image search. All right, this one looks like it may be. No. You guys have found it already? Is it a bow? It is a bow. Oh, Judge, I was using that picture. Uh-oh, when that box is on the desk, you might be in trouble. 187 family violence, is that what it is?
Please. Mm-hmm. Settle has arrived.
Okay.
Just right there.
All righty.
I got my taxes back from my accountant, and 3 average-sized trees had to die to print my taxes off. It's nuts. Gobbledygook. Taxation is theft. Yes. Did you itemize every super chat? Greeters, it's funny you should ask this. I was actually going to do a live stream about this, specifically for content creators, because in a recent big piece of legislation, where big may have been in the title, changes were made to the tax code that affects YouTubers specifically, like lists online content creators specifically. And as part of the no taxation on tips philosophy for the federal government, $25,000 a year of super chats or super stickers, as well as direct donations like a Venmo, PayPal, or Cash App, become non-taxable income. That's huge. This is not tax advice. I'm just telling you the news of what what was released. Let me read to you from a tax advisor who sent this to me. Let's see. The Treasury Department. This is I'm reading from a tax advisor. The Treasury Department issued final regulations today with rules on who can claim the new no tax on tips deduction. And his advice to me was that my online work qualifies, and he says definitely something for your tax preparer to consider. And then it has the screenshot with the exception number 209, digital content creators who produce and publish digital platforms, original entertainment, and personality-driven content such as live streams, short-form videos, or podcasts. And those would be streamers, online video creators, social media, influencers, and podcasters. And so they look under 27-2099. And there you go. So, Slot Life's like...
Oh, I've already signed it. I gave it to her.
They work like tips. Up to 20,
this is a different one?
Do gifted memberships count as tips? That I don't know. Because the rule specifically addresses donations where nothing
So what,
is
this is a different one?
No, it's the same one.
Okay. All righty, no problem. You're welcome.
Yeah.
Greetings, it doesn't care where it comes from. Anyway, so we start with tech and on to tax rules. You know, we try to cover all our bases here. We've got a diverse group.
Okay.
Want to send RA taxable income? Venmo it. Not a tax tip, just a question to ask your tax advisor. Ask them if you qualify.
No, this one I've signed.
For the no tax on tips.
Signatures on that one.
Okay.
Okay, all right. No problem.
And it's retroactive, so it's this year is when you'd claim it for the past year.
Oh, no problem.
I've already filed mine
Megan,
before this change took place.
on this, does the state have any objection?
Hey, Megan, welcome. Did we find out the purse? I cannot find the purse. D&B, it's got white with a little black accent trim.
Okay.
It's a Dave Matthews Band purse. No, not, I think it's D and B, not Dave Matthews Band. YouTube chose this moment to tell me that now would be a good time to insert ads. Creators earn more money inserting ads the more viewers are watching. Give it a try. No, thank you. I'll save you those ones. A Karl Lagerfeld brand. Approximate cost on the KL brand purse. Anybody? Dooney and Bork. That's it. D&B. Taxes are killing me this year. I'm sorry, Tammy. Then you've got other countries to deal with as well. Maybe, possibly. Checking to no tax on overtime, too. I'm pretty sure I don't fall in the overtime category. There have been very few days where I put in more than 8 hours. I'm sitting waiting to talk to the IRS because I entered the wrong account number to pay our taxes. Bounce check. Oh, my goodness. Oh, AC's Wildflower, I am so sorry. It's Bork. It's pronounced Burke. Burke. That's how it's pronounced. Okay. Then they spelled it wrong. Well, I was jumping to Judge Boyd because right before we jumped to her, she was laughing and talking to somebody. I thought, oh, she's going to have a pretty exciting morning. And then since then, she's basically spoken 3 words, which are like, Megan, here, I'm sorry. Bjork, not Bork. Bjork. Okay. I've got 2 sons who have to do taxes today. They're both in college. They don't know a penny because I don't think they've earned a penny. Well, they have earned a tiny bit, but not enough to owe anything. All right. A couple more attorneys working their way in. Does that mean we're going to start soon? Because a lot of people are waiting out there in the gallery, Judge. If we could maybe call a case or 2. Bless you. Bless you. 2 sneezes.
Thank you. I think allergies are getting me, Rick. It's kicking in.
This is the flowers. Driftwood, big one's coming up on the April 28th. It's going to be the American Idol or the America's Got Talent. I forget. One of the competitors who won a golden buzzer. It's going to be that trial up in Ohio, but it's not about his performance.
Thank you.
It's later on this month.
Yeah, you're welcome.
Send ours to an accountant, but Dad did Dad's myself this year because his would be easy, says AC's Wildflower. That's a lot of taxes. I have to sign half these pages, though. It should be easier than this. First 2 pages are bills I owe to my accountant. And the next bundle is all things I need to sign. And then the rest of the stuff I have to keep on file for like 7 years. Yeah, 4 times that. Oh, it's getting fatter every year, and I'm not doing anything. Wait till I start buying and selling Bitcoin. Then it's going to get fat. That's going to be, it's like all this paperwork and you made $3 in Bitcoin transactions? I'm like, yep. Let's see. Can you look into the Jonathan Rinderknecht?
Hi.
Palisades Fire
Yes.
I'm sorry I missed your call again.
No problem. Okay, I love this.
I can't take credit for this year. I ran out of ideas, so
Who designed it?
It's a combination of ChatGPT and my support staff.
Okay, I love it.
AI.
But all I did is kind of refine it at the end. And the reason it's so big is because with my over 50 eyes,
yeah.
like I was looking at the proofs, and I'm like, I can't
read it.
Can you make it a little bit bigger?
So judge accepting gifts on the bench. Jonathan Rinderknecht, if he's the person who started the Palisades fire, yeah, I'm sure they're going to try to prosecute. The problem is this is California. I'm not sure how easy it would be to get coverage of that. Let's see. And it appears to be federal, so no coverage. The feds don't televise anything.
Scooby-Doo in the gang.
Where are
How
you?
they're not really the great people that you think they are.
Oh, there's a story that they're actually drug dealers.
Yeah.
And so that
They're getting their mugshots in my medal.
the mystery machine is a mobile lab.
Yeah.
Scooby and Shaggy are like the test subjects.
Yeah.
Fred's like the dealer.
I did not know that.
So, yeah.
And Velma's the chemist. Right.
Wow, I think this guy watches the show.
That's what's going. So, yeah, I was telling him, yeah, you need to be here.
Is that still?
Yeah, it's coming up. So Norma will be able to give you the date, but I think somebody probably needs to be here to help him with that.
Who's on it now?
Yeah, Scooby-Doo. That's what we came back from break talking about. And now we go back on break. Curly Q, thank you very much. Love it. 12 months. OG. Congratulations. What trials are we following? A bunch of them, but not all of them are happening today. We have to wait for them to start. So we follow little tiny cases in the meantime. We might be following one out of Thurston later today, but they start late. I did my own taxes up until I started YouTube. And then I just wasn't sure. It was easy up until then. Today I learned about Scooby-Doo. Okay. Well, Judge, if you're going to keep your camera off, we're going to go back to Judge Dad.
Tell me when you can pay this so I can help you.
Oh, wait.
If you persist in arguing with me about...
We're going to back up a little bit, apparently. Hang on.
If you persist in arguing with...
Hang on.
Now, I want to work with you. I want to work with...
Wait.
Do that for you. Mr. DeRozak, here's what I'm going to do. I'm going to let you prepare the judgment. This will be after hearing. If the defendant pays $2,200 by the 23rd, but take it up there today, okay? I'll extend your writ date until the 27th. And then you should be able to pay the balance, right?
Correct.
But I feel the love. Thank you so much.
If I paid the I'm making sure. Oh yeah, if I get to the 27th, I can have it paid before the 27th and have my new rent paid on the 1st.
Fantastic. So why don't we say, if defendant pay, yeah, I'll give you till the 23rd to pay, although I think you should just bring it there today. And then the balance, if you pay by the 23rd, $2,200, writ date extended until the 27th. Okay? Is that fair enough, Mr. DeRozak? Are you good with that, or you want it to word?
That's fine, Your Honor. Did you want me to set this up by hearing or by consent? What do you prefer?
I think just after hearing. I think after hearing.
So I'll be able to drop this off as soon as we get off the phone, Your Honor?
Yeah, bring it over there today. He's going to bring a judgment over. He's going to send me a judgment today. And then you just have to pay the remaining balance, which again will be $1,614.56 by the 27th. Okay?
All right.
Good luck.
1624.
What's that?
You said 1624. I was making sure I got the right
No,
amount.
I said 1614.56. After you pay the 2,200, you have to pay 1614.56 additional by the 27th.
Okay, cool. That sounds all right.
All right. Good luck.
Yeah.
He's like, cool.
Thanks.
That sounds all right. That's pretty good deal.
Preston Point versus Chanel Himes, 2601467. Good morning, ma'am. Your name, ma'am?
Chanel Himes.
Okay, you got to keep your voice up for me, nice and loud. Did you listen to and understand the rights on the video?
Yes, I did.
You wish to speak to a lawyer or apply for funding?
No, sir. No, Your
Mr.
Honor.
Drozak, your appearance?
Good morning, Your Honor. Mike DeRosak, appearing on behalf of the plaintiff, Preston Point.
How much does she owe in total?
In total, all in, we have $2,686.94.
Can you pay that, ma'am?
No, that's not correct. It's 12/14/25. As of March 26th with the fees. And then for April, it is with the fees 508, and it should make it like 1722.25.
Wait a minute. He's indicating a rental rate on his complaint of $1,450.
Yes, but there was a subsidy for that, so the amount was only
they
$383.
don't have
I'm
to
looking at
include
the
the
ledger. I'm sorry. Say that again, sir.
They don't have to include the subsidy in their amount if the.
Okay, I'm basing it off of what I received in my door. They're going to still receive.
Slow down 1 second. 1 second.
Yes,
What
sir.
was the total amount owed as of March the 26th, you said?
On this ledger I received in my door with the court, it was $1,214.25.
So, but they're entitled now to the $1,450, right? Plus a late fee for April, right?
This was just through March, and then April would be $383 as my portion plus their $125 late fee. So
Have
that
they
would
been
be
paid?
another.
Have you guys received the? I don't know who the subsidy is coming from. Have you received any payment from them?
We have not received a payment, Your Honor, since March 9, according to the ledger.
So on my math, you got $2664.25 plus a late fee. I don't know. I think they shortchanged themselves.
No, the total amount should be, Your Honor, because it was the note in my door was for the $965.25, which was correct with their late fees. Then they added $250 in legal fees on the 26th of March. And
Well, what are your late fees?
$50 a month, Your Honor.
The late fee, they're charging $50 and $75. And so $125 a month in late fees each month. $249 in legal fees. My rent is $383 for the month of April.
But your rent isn't $383 if it's $1,450 and the rest is being paid by somebody else.
It's being paid by the veterans program, the veteran housing program.
All right, let's slow
they
down.
pay the
Let's
HAP
slow
program
down
pays.
here. Let's slow
Yes,
down
sir.
here. Let's slow down here. You know I'm not going to give you $125 a month in late fees. I'm going to give you $75 in late fees at maximum. The complaint says the monthly late fee is $50.
That's what I have written down from my review of the lease. I don't know that they actually charge this $125 that Ms. Himes is stating, but I'm happy to.
It is charged.
To
It's in the
review to
ledger
make
that
sure
the-
that it's not in there, Judge. I know we can't do $125 in your court.
So
it's in the ledger. I'm looking at the ledger, Your Honor.
Wait,
that, I guess the
please
bailiff on the door.
You're really interrupting now. Please.
I'm
trying to get to the bottom of this, and you want to keep insisting that your portion of the rent is only $386 or whatever you're telling me. That's great, but they have the right to charge any balance on this account. So if you owed $1,214.25, and the rent, if it's true, is $1,450 per month, whether it's coming from you or the veterans program, it's $2664.25 plus a late fee of $50, and that's $2714.25 plus any cost. So I don't know why you're saying you only owe $1,500 or thereabouts. They're entitled to charge that if they haven't received it from the veterans program.
Use
it's incumbent upon you to call them up and say, listen, they're going to throw me out of here if the judge doesn't, if you don't make this payment for me. So he's an officer in the court. He's not going to lie to me. If he did, he'd have big problems. Plus, he's never lied to me before, and I know he wouldn't lie to me now. And he's not going to tell me that they've not received the payment from the Veterans Program if they've received the payment from the Veterans Program. Now, I want to work with you. I want to work with you and help you make this payment if I can. I certainly want to do that for you, ma'am. But we got to get past what is owed first. And I'm not quite clear why you're telling me it's only $1,500 or something, because they don't have to take into account.
Yes, sir.
Well, tell me now. I've explained to you, but
Okay,
I don't want to
sir.
argue about this either.
No, I'm not. I promise you I'm not, Your Honor. I'm at work right now at the VA, and I'm just trying to explain what I received in my door. I've never received a ledger before. I'm holding the whole packet that came in the door with a ledger that I've never seen before attached. And at the bottom of this ledger that they printed out, that I guess the bailiff or whomever put into my door, says March 26th, the total fees due is $1214.25 through the end of March.
Yeah, but your April rent's due now.
I understand that, but what I was trying to explain to you, Your Honor, was that they receive a check from the HAP for the subsidy. It says Section 8 HUD rent as a HUD VASH program as a vet. Okay, they may not have received that payment yet, Your Honor, of 1067. That could be why they're factoring in it being 1450. That's what I was trying to explain. But at the end of this ledger, it's saying I owe 1214.25. Then for the month of April, my portion of that subsidy, Your Honor, will be 383 plus their $50 late fee.
I'm trying
plus
to
their
tell you, I'm not just
$75
including your portion. That's not fair to them.
They're going to receive their payment from that program. They had in the past, and they will continue to do so. And it comes after my portion is paid. That's what I was trying to explain to you, Your Honor. So that's why I was saying they were going to still receive that 1067. I understand you're factoring it in, but
Your Honor, I expect that we will receive the 1067. Of course, I have no idea when that will be. I have no problem extending the writ date a bit if that would give Ms. Himes some comfort. That would give additional time for that.
Well, that's what I'm trying to do, but I don't want to keep going through this. I mean, I don't understand why you're even at only 2664.20, whatever you told me, 2686.94. You should be more than that. But I don't know. I'm good to give you the 2686.94 because I'm convinced that you're at least entitled to that. And if I do the math on this, including your filing service and statutory attorney fees, you're going to be closer to $3,000. But I'll give you the 2686.94.
I don't owe that.
Why are you shaking your head, ma'am? Why are you doing that? I don't want to argue with you.
No, I'm not. My portion total, Your Honor, as of today, Your Honor, with April's rent and the late fees would have been $1,742. And I understand you're factoring in at $1,450, but they're going to get the 1067 for the month of March and the 1067 for the month of April from that agency. So based on this ledger, I have this 1214.25 through the end of March 26th. I was just going to ask for an extension for my subsidy portion for the month of April with the late fees, which would have been 508. And I was going to ask.
Hang on. Am I missing something? You are free to tell me, Judge, I see your point and I'm wrong.
No, I don't think you're missing anything, Your Honor. And like I said, I'm happy to extend to the end of the month if that'll give Ms. Himes comfort to make her.
He wants to keep arguing with me, and I have no other way to do this. I'm sorry. I can extend this long enough for you to get on the phone and call him and say, send him the money. And I can extend it. You're going to keep interrupting me now today. I just can tell. I love it when people interrupt.
They're not going to send it until I send my portion. They're not going to pay it. I can't call them because they're not going to pay that portion. Your Honor, until I pay my portion. That's why I was trying to seek clarification on my portion. That's all, Your Honor. I'm not trying to argue. I just was trying to elaborate on the ledger. I'm not arguing with you, sir.
I'm going to give him a judgment amount of $2684.94, $2686.94. I'm convinced that between you and the agency, that is at least, I know you're shaking your head, but that's the amount that's at least owed. Now, I can extend the writ date. He's entitled to one on the 23rd, but I'll be happy to help you out here if you just tell me what you can afford to pay and when.
Can you please give me a breakdown of this 2686.84?
Go ahead, Mr. DeRosa. 2686.94, I think you told me, right?
Correct. That's the total. And what I did, Your Honor, and perhaps what I've done is when I took out some of those $75 late fees that I saw on the ledger. So what I show is rent to retain possession of $2,290.25. 3 months of late fees at $50 each of $150. I have court costs of $246.69, which gets me to the total of $2,686.94, if my math is correct.
Okay,
and is that paying me through April, Your Honor?
Yeah, that would take care of everything through the end of April.
That's correct.
And 2290, can you break that down? How you got 2290? Is that 1450 times 2? Is what I'm just asking.
That one's a little more difficult because the last zero balance I see is October of 2025. So there's been payments made here and there, so it's not a flat 2 months. We'd have to go back penny by penny for many, many months to get to the last zero balance to move forward to figure out exactly.
Well, I'll tell you how I'm calculating it, ma'am. You told me that as of March the 26th, and you seem to adopt this, that the total amount that you owed according to the ledger was $1,214.25. Whether you agree with it, like it, don't like it, I'm adding in the $1,450 for the month, starting April 1, which brings the total to $2,664.25 plus a $50 late fee, which would take it to $2,714.25, and that doesn't even include your court costs or statutory attorney fee, which he just spelled out is another $396.69. So at the very minimum, you're getting a break here. Now, I'm going to order that, and I'm not going to argue with you. I'll invite you to tell me when you can pay. You're shaking your head. I hate when people shake their head at me. I just hate that. Because you want to get off here and tell everybody I'm the worst judge in the country, feel free.
No,
I hate
that.
That's disrespectful. And I'm not going to argue with you anymore. I'm going to try to help you.
I wasn't arguing. I was apologizing, Your Honor. I said I apologize.
You're shaking your head at me. You've been shaking your head.
Because they're going to pay them $1067 for each month they have in the past.
I mean, I get it.
And
I've already gone through this with you 3 times.
And he's saying zero balance has been October, but I paid the $900
I'm not reconsidering. I'm asking you to tell me when you can pay this so I can help you. If you persist in arguing with me about who's going to pay who, when, and how much, I'm just giving you April 23rd. Period.
I won't. Okay, Your Honor. Will that include them making their payment of the 1067 through the agency for March and April?
Yes,
April
that
30th?
includes this payment. Yes.
Would that be, Your Honor, would that be subtracting from the amount that you're saying that I owe? Because I only owe what I tried to explain.
Yes. It would be subtracted. Absolutely. I'm not trying to stick you with this and then have them say they still got to pay them the 100,000 and whatever amount of dollars. This is all included. They're entitled to a judgment on the rent that's owed, whether as to what has not been paid. And that's what I'm trying to tell you nicely, and you want to just keep arguing with me. Can you pay all of this?
I was trying to understand. What is the exact amount that you're saying, sir?
Can you pay all of this money, including the subsidy money, which you will be credited for, by April the 23rd or April the 30th? Can you do that?
April the 30th, but what is the full amount, Your Honor, that you're referencing? The 2290, Your Honor, 25?
No, 2686.94.
I have 1214 and 25 cents that was at the end of the ledger. Can I pay that tomorrow when I'm off? I currently have 1214.25 in a money order, which was through the end of this ledger. Can I make that payment at the office tomorrow, please, and then subtract that from this 2686.96 that that is being
I'll tell you what I'm going to do. Defendant to pay 1214.25 by April the 14th, And if she pays that amount, the writ date is extended until the 30th of April. Okay, so you pay that 12/14/25. They should be able to then pay the subsidy kick in. And all of that's added in, and the total amount that's paid between you and the Veterans Program will be $2686.94.
Very good, Your
Okay.
Honor. I'll do
Yes,
that.
sir. Now, yes, sir.
All right. Thank you very much. You'll submit that order, Mr. DeRozak?
Yep, we'll get that prepared and
I'll
submitted
receive
right away.
something
Your
in the
Honor.
mail.
You'll receive that. You should have it from me signed in the next day or so, ma'am.
Thank you, Your Honor.
Good luck to you. Thank you. Thank you, Mr. DeRozak.
Thank you, Your Honor. Good seeing you again.
Too.
Wow. Yeah, Skip, you can call whenever. You can call whenever. It's fine. Let's see. Judge gets up, walks away, and slams the door. Of course, the door doesn't slam, but he's fed up. Don't shake your head at the judge. See if he's
49950
back
is
from his
he
break. Hang on one second. Let's see. He's still doing a lot of collection stuff.
Yes.
Which is sad, but let's give him a minute to come back here. It was frustrating. He works with the law.
All right, stay seated, please. Okay.
Those are just things in your files to sign. The new.
Give me 1 second here.
Take a look at Thurston and see if they're up yet.
All right. Riverside Townhome. It's Kim Morgan, 2601289.
Yes, Your Honor.
You have to start your video, ma'am.
Good morning,
I'm
Your
doing
Honor.
that
Mark Landau
right
on behalf-
now.
Good morning, Mr. Landau. Your appearance?
Mark Landau on behalf of the plaintiff.
Miss Morgan, start your video and then tell me your name, okay?
Okay, it says I'm trying to start it. Here, let's see. Oh, it should be good now.
No, it's not.
It's
Bottom
not.
left-hand corner of your screen.
Yeah, I keep hitting it. It's start my video. Yes.
There you go.
Your name?
Kimberly Morgan.
All right, what are we doing on this one here, Miss? Did you two talk, Mr. Landau?
We did briefly, Your Honor, and we spoke last week as well. We've agreed to the terms of a consent judgment.
Okay, go ahead and put those on.
The rent to retain possession is $2,826.08 in rent, $150 in late fees for 2 months at $75 a piece. So the rent to retain possession is $2,976.08 plus $182.04 in court costs. The total is $3,158.12.
We agree that you owe that?
Sorry,
Okay.
Your Honor.
Yes, Your Honor.
To interrupt. Ms. Morgan and I agreed to extend her pay or vacate date out to April 30.
All right, do you agree to those terms, ma'am?
Yes, I do.
So you understand that you have until April 30th to pay that amount or vacate. If you do neither one of those, then they're going to present an application for a writ. I'm going to sign it and you're going to be evicted. Do you understand that?
Yes, Your Honor.
Does Mr. Landau have your permission to sign your name to that proposed consent judgment?
Yes, Your Honor.
You have 3 business days, since you're unrepresented by a lawyer, to come in here and fill out a motion to set aside that judgment. You have 10 days to appeal this. Do you understand that?
Yes, Your Honor.
Fully understand everything.
Yes.
Any questions at all for me, ma'am?
No, not today.
Okay, I wish you well. Good luck. Thank you.
Thank you very much.
South Point Square versus Marquetta Brooks, 2601290. She's not here, right, Jen?
No, Your Honor, she did not check in.
So I'll go ahead and take a default on this one, Mr. Landau.
Your Honor, we're requesting the entry of a default judgment of possession for non-payment of rent. The rent owing is $911.91. Late fees have already been paid, so there's 0 in terms of late fees. $182.04 the court costs. Total is $1,093.95 with a writ issue if not paid in 10 days.
Defendant failed to appear. The relief request will be granted. That is a default judgment of possession in favor of plaintiff and against defendant. The amount to be paid to save it is $109,395. Writ date April 23rd. South Point Square versus Juliana Jones, 2601291.
Mark Landa for the plaintiff.
Ms. Jones did not appear with us, Your Honor.
You paid for a second mailing too, and besides that, she was here in April, so you can go ahead and take on April 6th, so you can take your default.
We are seeking the entry of a default judgment of possession for non-payment of rent. The rent owing is $2,167.46 plus $150 in late fees. That's at $75 for 2 months. The total rent to retain possession for the judgment is $2,317.46 plus $182.04 in court costs. Total is $2,499.50.
Defendant failed to appear. The relief request will be granted. That is default judgment of possession in favor of plaintiff and against defendant. Writ date will be the 23rd of April, 2026, and $2,499.50 is the amount to be paid to save it. I think that's it, right?
That's it.
That's it. That's just it. We're the judge ends abruptly. Let's see. Judge Boyd is still live. We have a couple others. Thurston County is not live yet. Got this one.
Your understanding of the plea offer?
Yes, Your Honor.
Do you wish to accept it?
Yes, Your Honor.
Are there any other terms to the offer that we've not disclosed on this record?
Just the ice fishing court.
For custody? No other terms. Thank you. Ms. Weisbach?
Great.
All right. Count 1 alleges failing to attend any treatment programming. Count 2 alleges failure to enroll in any mental health treatment. Count 3, failing to enroll in anger management. And finally, count 5, failing to report to the Lapeer Probation Department on September 3, 2025. Ms. Phillips, what are your pleas relative to those counts?
Guilty.
So you failed to do those things?
Yes, Your Honor.
Probation, the court takes judicial notice of the probation order, which indicates those programs were ordered. Is there any explanation as to why you didn't do any of these things?
Yes, Your Honor. There's a letter that I wrote to you to explain why.
We've got Mr. Aguirre as well.
Read this to the sentencing piece.
Okay.
But I can answer a couple of questions with regards to
Let's go to Mr.
And that's fine. And the court will not read any.
Mr. Aguirre, how are you doing?
And let's reinstate Ms. Wickham's bond, and let's give her another chance at this. But Ms. Wickham, you need to show up on that date, all right?
Yeah.
Okay.
And Your Honor, if the court is reinstating the bond in this case, the state would move to add as an additional condition of bond that the defendant appear in person for all future proceedings. And additionally, if the court is reinstating the bond in this case, it would appear that the motion for judgment on bond filed in January of this year is a moot point. So if that is the court's order, the state would move to withdraw the same.
Okay, that is allowed. But I do agree that Ms. Wickham needs to appear for all court appearances in person in Butler County, right where you are, Ms. Wickham, okay?
Yeah.
Okay, so yeah, you need to be there July 6th at 9 a.m. and turn in that application for court-appointed counsel before you leave today. All right? Okay. Anything further, Ms. Wickham?
No.
Anything further, Mr. Begier?
Not from the state, Your Honor.
All right.
Maybe Judge Webster's on break. We've had a couple
okay,
fill-in
let's
judges
take up
here in Kansas.
State of Kansas versus Michael Paps. That is 24 CR 431. Could parties announce appearances?
Jerry Begier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Michael Paps. Mr. Paps does not appear. And Judge, this appears to be a motion for judgment on bond. I don't take a position on that, but I would give the court the following information that Mr. Paps is in the Garfield County, Oklahoma jail. I did check this morning and he is still in their jail.
Does his bondsman know that?
Judge, I think there's a release of the bond that's on file. And I think that was part of the announcement on the release that he was in custody.
Okay. Mr. Regier, what is your position?
One moment, Your Honor. Your Honor, it does appear that a certain document, request for discharge of surety, was filed with the court in this matter on March 20th. I have not had the opportunity to peruse that in depth. I have no personal knowledge as to the defendant's current whereabouts, as I do not represent the defendant in these proceedings. So the state will defer to the court how it wishes to proceed concerning the motion for judgment on bond filed in this matter on January 7th.
I think I'm going to continue the motion for judgment on bond, see if we can get more information or verification that he's in jail, and let Judge Webster handle this when she gets back.
Very good, Your Honor.
Okay, so let's set that over to July 6th at 9 o'clock.
All right.
All right. Next case, State of Kansas versus Saeed Mohammed Rahman, case number 2025 TR 2440. Could counsel announce appearances?
Chair Regier on behalf of the state.
Your Honor, Darren Patterson, appearing on behalf of Saeed Rahman, who does appear. Saeed, could you turn on your video, please? Unmute. Thank you. Judge, I would announce this time to the sole charge of no proof of insurance. Mr. Rahman will be entering a plea of no contest.
Okay, and there's no plea agreement, just it's a no contest plea.
I call it a standard agreement. I think Mr. Regier says there are no standard agreements, but Mr. Regier, what requested is it acceptable?
Your Honor, while the state does maintain its position that every case is unique and worthy of individual consideration, the state is prepared to proceed in this matter.
Yes.
Okay. All right, Mr. Regier, can you provide a factual basis?
Yes, Your Honor. Were this case to proceed to trial, the state's evidence would show that a stop occurred on October 31st, 2025, involving a 2013 Nissan. The location of the ticket appears to be located within Butler County, or rather the location of the stop at I-35 at milepost 66. The state's understanding is that is between Towanda, Augusta, and El Dorado city limits, well within Butler County boundaries. Besides citing the defendant for one violation of KSA 43104, the state's evidence would show that the officer inquired as to whether the status of insurance at the time of the stop, and the defendant was unable to provide the same.
Mr. Patterson, anything you want to add to that?
No, Your Honor.
Okay, what are the recommendations for sentencing?
Yes, Your Honor. Pursuant to plea negotiations, the state would be recommending a $300 fine, the minimum required by law, that the court impose appropriate court costs and determine attorney fees. The state would further be recommending a suspended jail sentence of 120 days, subject to a non-reporting probation of 6 months, and any other orders of the court may deem appropriate.
So you have to be good for 6
Mr.
months or else you go to
Patterson,
jail.
anything you want to add to that or your recommendations?
We'd ask court to adopt the recommendations. I am court appointed.
Okay. All right. I'm going to find Mr. Raymond guilty of no proof of insurance and pursuant to the plea agreement, imposing a $300 fine, court costs. I'll come back to attorney's fees in a minute. We're going to do a 120-day jail sentence, but that's suspended. That's so no jail time and 6 months of non-reporting probation. Mr. Raymond, are you currently employed?
No, Judge. I am a student here.
You're a student?
Yeah.
Okay. Do you have any income?
No, of course not.
No income at all. Okay. Okay, all right, I'm not gonna impose any attorney's fees then.
Thank you.
Anything else, counsel?
From the state, Your Honor.
And Judge, just that we would ask the court to set a time that he would pay before it would go to collections.
Okay, Mr. Raymond, how long do you think you're gonna need to get this case paid off?
Approximate 3 months, ma'am, because I need to pay my semester fees in upcoming, and then after that I can able to pay.
I have to pay my
So do
school
you
fees
think you can
first.
get it paid within 90 days?
Sure.
Okay, Mr. Aguirre, is that okay with you?
If that is the court's order and if the journal entry may reflect the same, the state has no objection.
How's he going to pay?
Okay, well, that sounds reasonable to me. 90
He can't
days to
work
pay,
'cause he's
and
on a
after that,
student
it will be
visa,
going to
right?
collections, Mr. Raymond, all right?
All right.
All right, we are adjourned. You're free to go.
We've
Thank
got
you.
Judge,
for-
the standing judge, working
Drove
today
while
as
license
well.
expired and the civil infraction obstructed vision. Is that the way you want to resolve this today?
Yes.
Romulus.
And you understand your rights and the options those rights give you?
Yes.
Okay. Let me get some paperwork caught up here and we'll move forward.
I see the light.
Hey, thank you.
You're welcome.
Your phone is resting flat on your desk and you're leaning over it. With the light focused.
So did you drive a vehicle in Romulus on February 10, 2026?
Yes.
And what was going on that you think you're guilty of reckless driving?
Well, it was just childish friends hanging outside of the window. And they were, it's obstruction vision, you know. It was just childish.
And
all right, how old
dangerous.
I'm 21.
All right,
Old
well,
enough
what
to
was
know
going
better.
on? This wasn't another day at the races. How many passengers did you have?
We had 6 passengers, including myself.
Were you guys celebrating
the
some
driver?
kind of big event? What was going on?
Yeah, well, it was just basically we were celebrating one of my friends that was the passenger. Her and her man were breaking up or whatever.
Okay.
It was just a long story.
Okay.
I've never done this celebration. Hanging out the
All
passenger
right.
side of my best friend's ride for a breakup.
Factually, I can accept the plea. I'll dismiss the original 2 charges. Anything you want me to understand or consider before I sentence you?
No, thank you.
Are you working?
Currently I'm in the process of getting my job at assisted living care, taking care of the elderly.
Hopefully not giving them rides.
All right, so you're in the hiring process?
Yes. So I already
Okay.
basically got the job. I just had to take a physical.
Okay. And where did you work before that, if anywhere?
It was McDonald's for 4 years.
Okay.
Moving up.
Anything
I
else?
like it.
No, thank you.
All right, on the reckless driving charge, fines and costs are $500. I'm ordering 4 days on the court work program as an alternative to jail time. You get to pick which 4 days you work. You schedule those days. I see you're a local person. It's easier. You can do it online, but it's easier if you just come in here and set up your schedule. The $500, can you pay that today or do you need some options?
I just need some options sometime.
All right. Is there any reason why you can't come in here today to set up your work days and set up some kind of payment arrangements?
Yes, because of transportation.
Okay. When could you do that? When could you get a ride up?
Next time my friends are
Possibly
throwing a
if
party.
I could probably next week or this week. But
If
just
I
by
give
the
you
end
until
of the week.
Friday at 3 o'clock, do you think you can get in here?
Because everybody's working right now.
If I give you until Friday at 3, do you think you can arrange transportation?
Yeah.
All right. Do you have any questions at all?
No, thank you.
All right. Have a nice day.
You too.
Thank you.
Thank you.
Thank you.
There's no attorney on that one either.
Where are the guys at? You don't have to be running these.
Fine.
Where the guys at? Dante's ready. Judge left. Should we skip ahead? Because we can. In our courts, you must bow before the judge, then proceed, says Barb. I like the idea of showing a little respect. Oh, judge is back. Here we go. This is, I think he's still live. This is just, we backed up a little bit. This is morning docket today.
Dante Johnson.
Yeah.
Good morning, Mr. Johnson. Are you going forward today without benefit of a court-appointed attorney?
Yes, I am.
And did you understand your rights that you have today and the options those rights present to you?
Yes.
And how about the charge? Do you understand the possible penalty for the charge of registration or plate misdemeanor?
Yeah.
Understanding all of this, Mr. Johnson, are you pleading guilty to that charge today?
Yes.
Are you doing so freely and voluntarily? Are you pleading guilty because you've decided that's best for you or because somebody's telling you you have to? Are you having trouble hearing me, Mr. Johnson?
Yes, I'm pleading guilty.
Okay, we just lost you.
Dante. See if you can hold the phone a little higher. It's frozen.
Heather, where is Mr. Johnson located right now?
In custody, I can tell you that.
Livingston County Jail.
He just froze up on us.
Yeah, I see that.
Then we kicked him out.
He's gone now.
Gone. Yep.
He gone. He gone.
Hopefully we'll get him back.
Hi, Miss McLean.
Yes, can you hear me? I'm
I
so
can.
sorry I'm late. I'm in a different time zone. It's 7:33 here and it's 8:33 there. I'm sorry.
Could have been
That's fine.
worse.
Do you have camera?
Could have been in a
Yes,
different
ma'am.
galaxy.
So we changed you back to the 8819 Greenfield Road in Dearborn. Should it still be the Dallas, Texas address?
Yes, ma'am.
Hello. I don't know why we changed it back. So what's the Dallas, Texas address?
It's going to be 1222 North Bishop Ave. And that's going to be Suite 200-446.
I'm going to say filter.
Dallas, Texas 75208.
Okay, I'm sorry.
Dallas.
I should have filtered that out. I'm going to say she's got a filter on.
What was the zip?
We don't need it again.
8.
And it's Suite 200 dash.
Ma'am.
Alrighty.
Can I make myself look like I can?
All right.
But I'm not buying that she's in
for
San
today's
Francisco
proceedings,
either.
did you want to go forward with an attorney or without?
With an attorney.
All right, let me give you to the attorney.
She ate the blueberry candy from Wonka. I do think it's a camera effect, not a light.
Will I get in trouble for being late?
Yeah,
Nobody knows. What time was your hearing?
we know.
It's at 8 a.m. Eastern time.
Yeah, I'm not finding you there. Hold on, let me see. Actually, it's 8:20, so you're not that late.
She's an Aerosmith fan.
Okay. Thank you.
You're welcome.
Phil, Tile Toys, post this on Twitter. Naked burglar suspect has been arrested in Fairfax County, finally. This is this morning. Nude burglary suspect arrested by Fairfax County Police after they say he committed a series of early morning burglaries while nude in March and early April. My question is, were these breaking and entering? Because you didn't have any pockets for like lock picking tools and stuff. Let's see. Are we just waiting, Judge? Can we skip ahead? Do you mind? Got some attorneys waiting for... Oh, there he is. He walks in right here. Okay, we've got MDoc, John Grazzini. Grazzini, I think. Just wait for the judge. There he is.
Mr. Graziani, your appearance for Fuller.
Good morning, Judge. John Graziani, P number 43387 on behalf of Jamil Fuller. Please introduce yourself, Mr. Fuller.
Jamil Fuller.
Hey, Heather, Mr. Fuller is not on my printed docket, but I do have a file.
He is not.
Oh, he's an
Marlisa
add-on.
added him. Yeah.
I found him. Okay, just wasn't in alphabetical order. All right, Mr. Graziani, tell me what we got.
What's happened is Mr. Fuller originally had a reckless driving charge, discussed this matter with Prosecutor Manarino, and she's agreed to dismiss that and have Mr. Fuller plead responsible to careless driving, sir.
All right, Mr. Fuller, is that the way you want to resolve this today?
Yes, sir.
All right, and you've discussed your rights with counsel. You understand those rights?
Yes, sir.
Understand the options those rights give you today?
Yes, sir.
All right, I'll accept your plea of responsible to careless driving, dismiss the reckless. How long has he been where he's at, counsel?
I believe for about 3 months. Is that correct, Mr. Fuller?
No, I've been here since March 2nd.
Okay, I apologize. He caught a gun charge earlier, and I presumed he was there a little bit longer, Judge. My apologies.
How long are you going to be there, Mr. Fuller? Do you know?
Long time.
My sentence is 1 to 5, but I'm boot camp. Boot camp has permitted me. My judge in Wayne County has permitted me to go to boot camp, so I'm just waiting for boot camp to come and give me that's 90 days.
Man, I hope you know how lucky you are.
100%.
Wow, that's a gift, man. Don't screw that up, Mr. Fuller.
No, sir.
All right.
Judge, would you want me to deliver the plea form to your courtroom?
No, I don't need it.
Okay, thank you, sir.
All right, I'll waive or suspend fines and costs on the careless. You go take care of business in boot camp. Take advantage of
All
that.
right, thank you.
Thank you,
You're
Judge.
welcome.
Thank you.
Heather, are we done with the jail?
Goes from
With him, yes.
1 to 5
Heather,
with the.
can you get me the next person?
Yep, they're in your meeting room. If you can go back in your meeting room.
He's got 1 to 5 years on the
Yeah.
Mr. Fuller,
sentence.
just let the deputy know we're done with you. Thank you.
All right, I got you.
Do I press more? Where do I press, Heather?
I don't know, John.
Okay.
I don't have your
John,
computer.
just go back in your meeting room. Maybe the naked burglar was just hanging out. I wonder. I mean, yeah, it's one of those deals where if you're going to rob the place, it's an all you can carry type situation, right? Because there's one arm load. That's pretty much it. Naked burglar left his boots at boot camp. That was in Virginia, right? That's just north of me. Grab a pillowcase, duh. And maybe a gunny sack or something. Cut some leg holes in it and make yourself some shorts. I don't know. Oh man, the Harry Dresden dude, that was creepy. Did you see the follow-up one, Crafty Chris, where he went in the house, where he actually broke in? Yeah. Maybe he was looking for something specific, like pants, says Barbara. Dude was scary, yeah. Okay, skipping ahead. I like this judge. He can get some spicy cases that are interesting. Let's see. Nobody's here. There we go. Looks like we got somebody here. I'm gonna skip through his morning and see what happens. Right there, he walks in right here. All right.
You want to call for him?
Bless you, sir.
Counsel, your appearance on Harrison.
Thank you, Judge. John Graziani, P number 43387. Sir, I'm representing Mr. Harrison. Mr. Harrison, please enter your appearance. Please identify yourself, sir.
Yes, Your Honor. I'm Xavier Harrison.
Thank you. What do we got, counsel?
Judge, what's happened is Mr. Harrison's availing himself to 771.1 plea. He does not have a criminal history. I spoke with Prosecutor Manarino, and she has no problem with it. The recommendation is for a period of 6 months, and I've explained all the rights associated with that. The fact that Mr. Harrison still could go to jail, and then he's got a right to go to trial, bench or jury trial, and other things with the advice of rights, and he does want to enter the plea at this time, Judge.
Thank you. I think I talked to your passenger a few minutes ago.
Yes, Your Honor.
You guys work for the company that hauls appliances around for the big box stores?
Yes, Your Honor.
Yeah, okay. And did you understand your rights after talking to Mr. Graziati about same?
Yes, Your Honor.
You understand the options those rights give you?
Yes, Your Honor.
Understanding all of that, are you pleading guilty freely and voluntarily to this charge?
Do you understand the charge, Mr. Harrison?
Yes, Your Honor. I do. Yes, Your Honor.
You're pleading freely and voluntarily, sir, correct?
That of
You're
what
pleading
happened this
guilty
morning.
because you decided that's best for you, not because Mr. Graziani told you should.
No, Your Honor. I'm sorry. I'm sorry. I'm sorry, Your Honor. I'm sorry, Your Honor. I didn't mean to ask for an attorney. I'm sorry about that part. But yes, Your Honor, that I had the firearm myself. Yes, Your Honor.
Okay, all right.
I didn't want an attorney.
My understanding from talking to your truck mate is that you guys are traveling in Michigan on delivery. You had a pistol and loaded magazine in the vehicle. Neither one of you had a concealed pistol license. And in Michigan, that's improper transport of a firearm. Is that the factual basis?
Yes, Your Honor. It was unloaded. It was away from each other. It was unloaded. Nothing was in it. Nothing was in the
loaded magazine and the pistol were in the same compartment, correct?
Yes, Your Honor.
All right. Mr. Graziani, is satisfied?
Satisfied, Judge. Satisfied.
All right. Mr. Harrison, how long have you worked with the company?
For a year now.
Okay. All right. Anything else you want me to consider before I set the terms of sentence?
No, Your Honor.
Okay. As I told your coworker, usually on a charge like this, I would order work program days, but because you're an out-of-state resident, I'm going to convert that to community service hours.
Yes,
so, court costs are $500, 20 hours of charity work. I gave him 60 days to get the charity work done. I'll give you the same.
Yes,
so find a nonprofit that's registered with the IRS as a nonprofit, do your hours, official letterhead that shows you did 20 hours, and send that to us within 60 days. If you want us to pre-approve it before you spend the time, then you can go through our email and email what you're thinking, and we'll let you know whether or not that's going to work.
Yes, Your Honor.
Can you pay the money on line today, or do you need some time?
I need some time, Your Honor.
All right. How about 30 days on the money?
Yes, Your Honor.
All right. So within 30 days, the money, and then within 60 days, the hours.
Yes, Your Honor.
Any questions?
No, Your Honor.
All right, good luck to you. Stay safe.
Yes,
Thank
sir.
Thank you so much.
All right, John, I think you have one left, and then you
Okay.
should be good to do the lives. I'll move
Okay.
you in.
Thank you so much, Heather. Thank
You're
you.
welcome.
Good morning, Mr. Greco.
Good morning, Judge. And we just had a civil infraction plea involving Ms. Elizabeth Ellison for TC October that we just gave to Heather for her to
Alrighty.
process.
Okay.
Thank you.
Thank you.
Mr. Benavides, do you need to speak to your client?
No, we're ready.
You ready? Alrighty.
Yes.
Judge.
Elizabeth, you can go.
Thank you so much. Can I have 14 days, Heather?
Yep, I'll put it down.
Thank you.
Yep.
Are you pulling Ogden?
Oh, no, I need to pull.
Counsel, your appearance on Ogden.
Good morning, Marcel Benavides on behalf of Mr. Clinton Ogden.
And Mr. Ogden, are you there?
Yes. Yep.
Thank you. Counsel, I understand this is a dismissal. I'm going to bet that you and Mr. Ogden are okay with that.
We are, Judge. Asking for dismissal with prejudice that
It won't be with prejudice because I don't have a jury impaneled and I haven't sworn in a witness.
That's fine, Judge. Thank you.
Mr. Ogden, did you post any cash bond?
I did not.
Then the case is dismissed. You're all set. You fellas have a nice day.
He's gone.
Awesome. Thank you.
He gone.
Mr. Kewen, are we ready on Thompson?
We are ready, Your Honor. I'm going to pull him out right now. Thank you.
All righty.
Your Honor, this is Attorney Benavides. May I ask a quick question?
Sure.
Will the clerk input the dismissal into the system so that the licensing sanction is removed? The 625.
Yeah, that'll be done momentarily. She's doing real-time dispositions.
Okay, great. Wonderful. Thank you.
You're welcome.
Have a great day.
Counsel, your appearance for Mr. Thompson.
Good morning, Your Honor. Tim QNP 64917 appearing today on behalf of Mr. Thompson, who's joining us today via Zoom. Mr. Thompson, can you state your name, sir?
Yes, sir. Good morning, Your Honor. Lance Thompson.
Thank you. Counsel, tell me about the plea.
Thank you, Your Honor. Today's the time and date set for pretrial. I've been able to pretrial this matter on a few different occasions with the city attorney. City attorney has agreed to dismiss the original count, which is an OWI case from the year of 2020, with the understanding that defendant would plead guilty to an added count of reckless driving from that same time and date. Defendant has been advised of his rights, in particular, Your Honor, his right to trial. He'd be willing to waive those rights and avail himself of the plea today. Again, Your Honor, this is a case from 2020. Currently, Your Honor, the defendant is at the Michigan Department of Corrections. He will be there for at least the next year with a significant parole tail to follow.
All right. And Mr. Thompson, how long have you been incarcerated already?
I've been here I've been locked up for a year and some months.
Okay. All right. And did you discuss your rights with counsel? Do you understand those rights and the options they give you?
Yes, Your Honor.
And do you understand the possible penalty for reckless driving?
Yes, Your Honor.
All right. Understanding all of that, are you pleading guilty freely and voluntarily to that charge?
Yes, Your Honor.
Did you drive a vehicle on October 10, 2020 in the city of Romulus?
Yes, Your Honor.
And what's the factual basis for the reckless, Mr. Kewen?
Thank you, Your Honor. At that time, sir, were you operating that vehicle well over the speed limit? In fact, were you speeding significantly while you were driving? Is that correct?
Yes.
Is it also true at that point in time, one of your headlights was out? Is that correct? And it was after dark?
Yes, correct.
And you were weaving in and out of traffic. Is that correct?
Yes.
Judge, and for purposes of this plea, we would stipulate that there was alcohol in the defendant's system at that point in time. And I would be satisfied with that basis. Would you be satisfied, Your Honor?
I am, counsel.
Thank you, Your Honor.
All right. I'm going to set Mr. Thompson, I'm going to sentence you to 93 days in jail, give you credit for time you've already served. File is closed.
Thank you, Your Honor.
Thank you, Your Honor. Appreciate it.
Thank you, counsel.
Good luck, sir.
All right. Thank you. You too.
Okay, Judge, we got some walk-ins.
Is that what we got here? What are we doing? I won't find it. Dustin? All right, ladies, give me just a minute. I want to get files so Heather, so she can keep working.
Thanks, Judge.
I'll just give you those. All right, appearances.
Thanks for carrying out the record. Speaking to how we defended.
Thank you. Sir, you can sit. They train the attorneys to jump up. You're okay. All right, so I had a chance to look at the pleadings. Let's just go over the high points, and I'll give Ms. Manarino a chance to respond.
Motion set aside to default judgment. It all arose due to issues surrounding my client's driveway, which the city has left.
You just do one window.
Oh, you're done?
Yeah.
Oh, okay. Just a moment.
Go ahead. I muted that.
Not the case, Your Honor. It's not being used for a drug draft. Basically, the whole issue had arose when my client had hosted a memorial gathering with friends and family, and they had warned the police at the time of this event, of course, because they just wanted to make sure that the city was aware if there were any issues. And basically, my client, Mrs. McAllister, was his wife, had received a noise violation ticket, which we had handled previously. This matter, Your Honor, is a completely separate ticket. It came as a surprise to my client because there hadn't been any noise issues at the time of it being issued. And basically, Your Honor, we appeared originally, counsel and I had agreed for the first adjournment of the matter because my clients wanted to discuss directly with the city. My office had previously discussed with the city a few months ago as well, and that there were subsequent discussions that my client wanted to discuss directly with the city without both counsel present. So that meeting date was scheduled the second day after our original hearing here in court. So I had contacted counsel to request an adjournment so that our clients can go ahead and discuss directly. Counsel did not object to that adjournment, and unfortunately, there was a misunderstanding as far as that getting translated over to the court. I know my client be held accountable for that. If anything, I'll take the blame for that if I have to take the blame for it. So basically, at this point, my client does want to just get the ticket because again, there is no commercial use of this property, of this driveway whatsoever. So he does have valid defenses and there's raised defense in this matter, and there is good faith for this default to be set aside.
That was
Your Honor, the strongest evidence of the commercial use of this property come from the defendant's own mouth. There is a website, there is business, there is promotional materials that he's posted on numerous social media channels. The memorial event was something he posted on TikTok inviting anyone who saw the video to. There were people in staff t-shirts, including the defendant. This is the idea that we're going to argue to the court that this is not a commercial business flies in the face of every single word that has come out of the defendant's own mouth. It's not remotely true. And so for the court to set aside the default based on a misunderstanding, I could see where the court would come to that conclusion. But the issue is there's not a meritorious defense using the defendant's own words about what the property was being used for. And I understand that there's going to argue that they haven't been using it recently, but the problem is that the businesses are still active businesses with the state. The videos were still posted, and what we would have would be the defendant's own word that he's not going to continue to use this property as a commercial property, except that after the last time they told the township they wanted to do it, they continue doing it because we got to do phone noise complaints. The issue is that the township has asked them to provide plans for what they're going to do with the driveway. We had a meeting where council, the McAllisters, myself, the building department were all present. And during that meeting, the township made it very, very, very clear to the McAllisters that the way that the township is going to be comfortable that this is not going to be used as a drift track any longer is to remove the portions of the track that you can drift around, i.e. all of the curves in the corners. The plans they submitted were we're going to leave the driveway as is and we're just not going to use it. The township was not agreeable to that, obviously, because that was against our entire position. And we've been waiting for months now for them to submit new plans. It's been nothing but adjournment request, dragging it out. The meeting that they scheduled with the building department, they canceled at the last minute after to reschedule it. The township's not asking for engineer drawings, but for whatever reason, defendant seems to think that that is what the township's requesting, despite the fact that the township has repeatedly said, we just need something that can be rough sketch, like just nothing formal, nothing engineered, but just something to give us an idea of what they're proposing, so that we can have some discussion. We can't have discussions when their plan is, we're gonna leave everything as is, and we're asking you to trust us, when we've given you no reason to trust us. Then we're gonna keep our word.
I feel like I'm missing half the story here.
So there's really, the way that we conveyed, should have conveyed to the court that the quick case being adjourned was by notifying the court that didn't happen. And there's no defense to this ticket. There's obvious commercial use of the property from the defendant's own words. We would ask the court to deny the motion.
All right, so counsel, even if I give you the good cause for the default, I don't see the meritorious defense.
We also provide some clarity as far as the company itself. That company, Sideways, is actually a clothing company. And my clients are in the process of getting an actual commercial-based drift track in place in a whole separate city with the proper licensing and the proper planning and making sure that everything is in place in order to have an actual drift track. That's not relating to this Van Buren Township property. It's completely separate. And like I said before, the main complaint was from that Blood Memorial event. Unfortunately now, whenever anyone in the community is hearing any type of noise, they're automatically assuming that it's my finding. And that's not the case, because officers have appeared several times to my client's property and they've all showed up and said, why are we here? Nothing is happening. At this point.
So let me ask you this, sorry to cut you off. I'm assuming, I know nothing about drift tracks, but from what Ms. Manarino said, this roadway has a number of curves in it, including like a loop. Is that right? Okay. Nobody puts a driveway in like that. Nobody in the history of mankind puts a driveway in like that. So are you going to be able to establish at hearing that this other site that they've been working on has been in place since before November of 2025?
The exact timing goes, Your Honor, but I do know that it's something that's been in the works as far as, of course, them having a company that they're working on establishing and building up for this track purpose. And as far as the proposal goes, in order to handle the current driveway that's in place, my client had previously submitted a proposal where they wanted to build different structures on their property in order to make use of this driveway. My client's a car enthusiast.
But it's not a driveway. It's not a driveway, counsel. Under any stretch of the imagination, nobody puts in a figure-8 driveway. They put in figure-8 tracks. Motion's denied. $230 is what you owe us, Mr. McAllister. When do you want to pay that?
Nobody puts in a figure-8 driveway.
You can. So what's next? I mean, the problem's not resolved.
No, you're kind of down to the full, but not to see you filing a motion here with the driver.
All right.
Thank you.
Have a good day.
I need to see this figure-8 driveway. And a memorial, like a funeral memorial at a figure-8 racetrack driveway streamed on TikTok. What?
You don't put a diplomatic plate on a hoot.
Yeah, you don't. I like driving those little slick track cars. Those are fun. All right, let's Judge, you're coming back, right? Yeah, here we go. See what type of morning he had. Just waiting for audio, Judge. And you control that.
Use your phone.
Judge, I'm going to fast forward you.
Muted. You try him.
There we go.
Mr. Balvich, what are we doing on Alan? No show?
I haven't seen him yet, Heather.
Yeah, he hasn't jumped on yet, so we'll put him in the no-show pile.
All right, he's an hour late, so I assume he's not coming.
It's okay. No one gets in trouble for being late in this court.
All right, I'm gonna, if you need me, call me. I'm gonna leave the meeting.
Well, we physically could use you if you're up for it.
Oh, absolutely. Yeah.
Rodney's here and he's thinking.
Beg your pardon?
Mr. Graziani desperately needs help.
Then I will help him.
We appreciate it.
Yep.
You'll come in?
Yeah, it says here, join a breakout room with Angela.
Yeah, I'm not on Zoom. I need him in person.
No, we would really like it in person if you could actually make it.
Judge, I'll be there in 15 minutes.
Thanks.
Ooh.
We just want to communicate it with the
You must have an office
Appreciate
right next
it.
to the courthouse.
Yep.
Yeah. What are we doing with Hughes?
I'm just, Jamie said.
You got Hughes?
I sure do.
It's the civil infraction.
Okay. Cross it up.
So Graziani is the only one that's out there? How did they send us just one?
We've always only had one on our violation docket.
Oh, this is all violations?
Docket and that just happened within the past couple months, so now we've
Yeah.
learned we need two or three.
Mr. Hughes, can you hear me all right?
Yes, Your Honor. Good morning.
All right. The prosecutor asked me to dismiss the charge from February 23rd and return your bond. I'm assuming that's okay with you.
Yes, sir.
Have a lovely day, sir. We'll process that and send you a check.
Thank you, sir. Appreciate it.
You done? Can you dismiss?
Am I
I'm gonna
dismissed,
kick you
sir?
out. I'm going to kick you out. Yep. Have a great day. He gone.
He gone.
Take care of these, and then I'll be back. Definitely stuff out too. And then Elizabeth,
How was your dizzy?
it's still, but Elizabeth Moore
Yeah.
for that trial. She's like, remember we had asked about doing a Zoom test. She goes, my client's gonna do it today at 4.
Yeah.
I'm like, I leave it for me. But I'm gonna leave your Zoom up and just ask somebody downstairs to jump on, just to be host.
Yeah.
And then and so I told her I was gonna do that.
Yeah, that'll work.
Yeah.
Okay, Judge. He walks off again. He's getting his steps in, that's for sure. Let's see. Wait for, he comes back right here.
Mr. Graziani, your appearance for McLean while I find the file.
Okay, thank you, Judge. John Graziani, P number 43387, appearing on behalf of Ms. McLean. Ms. McLean, please identify yourself.
Good morning, Judge. This is Aviana Janae McLean.
Thank you, ma'am. Counsel, go ahead and tell me what we got.
Judge, discuss this matter with the prosecutor, and the defendant is in agreement to pleading guilty to the harassing phone calls. She pledges that she will not call her grandmother again. And if the judge allows, if you allow, Judge, she'll take it under 771.1, which would be the delayed sentence.
And was there a time frame discussed between you and the prosecutor, counsel?
It's a 12-month time frame that she offered, Judge.
Thank you. All right, Ms. McLean, did you discuss, can you activate your camera, ma'am?
Yes, sir. Can you see me?
Sort of.
I can. Did you discuss your rights and options with Mr. Graziani?
Yes, sir.
Do you understand those rights and the options they present?
Yes, sir.
All right. And do you understand the possible penalty for the charge?
Yes, sir.
Understanding all of this, are you pleading guilty to that charge freely and voluntarily today?
Yes, sir.
Counsel, if you would like to voir dire to get the facts to satisfy the plea, February 9, 2026 is the date on the file.
Hey, thank you, Judge. Ms. McLean, is it true that on that date that you made numerous phone calls to your grandmother?
Yes, sir.
And did she indicate she didn't want to talk to you?
No, sir.
No, we spoke earlier, and she wanted you to
yes.
stop.
Yes, sir. She did want me to stop.
And but you still continued calling her. Is that correct, Ms. McLean?
Yes, sir.
Okay.
Why?
Judge, I'm satisfied.
I'm satisfied as well. All right, I will accept the plea. And let's see, you're in Dallas, correct?
Yes, sir.
All right. Are you working?
Yes, sir.
Where do you work?
Say it one more time.
Where do you work?
I work for Garter World doing security for Google.
Thank you.
Security for Google?
All right. It says, I got paperwork here that says you got a file from 2025, malicious destruction of a building. You're on probation.
Yes, sir. That's with my grandma.
Okay. And it looks like you were just placed on probation this January. Is that right?
Yes, sir. That was with my grandma.
Yeah. How long is your probation? Was it 12 months?
Yes, sir. And restitution has been paid in full.
Yeah. It looks like you already paid off all the money. You just got to stay out of trouble for 12 months, right?
That's a fair deal.
Anything else you got to do for probation?
None that I'm aware of. I do need to follow up with Mr. Grant after this court hearing.
Yeah. Make sure there's no other stuff, no other boxes you got to check to be successful on probation.
Yes, sir. Will do.
All right. Anything else you want me to consider before I sentence you on today's file?
Judge,
No,
she's
sir.
been gainfully employed. She's got an excellent work record. She had a very difficult upbringing. Homeschooling has been thought that it's a lot of people think homeschooling is great. It should actually be a hybrid program. That's my little assessment. But as a result, Ms. McLean did not have much interaction with other folks during her troubled childhood. And as a result, she became quite dependent on her family, her mom, and her grandmother. And as a result, it created these problems. And she's gainfully employed. She makes almost $30 an hour. She went to Wayne State for 3 years. And I think she's got a bright future. But like all of us, she may need some counseling, Judge.
Okay. All right. So my concern is it looks like the incident date on this one is 2/9/26. It was after she was sentenced. This could be a violation of probation.
Yep.
Judge, I realize that. I still believe that she would qualify. You know, I discussed that with Miss Manarino, and she indicated that she could still qualify for 771.1.
Okay, but that doesn't mean she won't have a problem with the probation file.
Understood, Judge. Understood. Okay. I explained.
Okay. All right. Okay.
I think quite frankly, it arose out of a same incident of anger and, you know, a little bit of stupidity. But like I said, Miss McLean's got a very bright future.
Okay. All right. Miss McLean, anything else before I sentence on this file?
Yes. So you said that it could be a violation. How does that work now? If it is a violation.
Anytime we put somebody on probation, one of the terms of probation is you stay out of trouble, no further offenses. So if you were sentenced on January 6, 2026, but yet this charge came up in February, whoever sentenced you, I'm assuming it's Judge Martin?
Yes, sir.
Okay. So Judge Martin could violate your probation because of this charge I'm taking the plea on. Whether or not she does or not, I have no idea. I don't know what conversation she had with you when you were sentenced. I'm just telling you.
So wait, I have a question, Judge. That incident for February 9th, I was already in Dallas, Texas, and had no communication with her. I did communicate with my grandma starting from Halloween up until my court date in January. But I never made contact with her in February because I was already in Dallas, Texas on January 10th.
Okay. So
it could just be because of the filing with the delay, but I can guarantee you I didn't have contact with her after January 10th of this year.
You just pled guilty.
Well,
though.
if that's the case, you probably won't have any problems with your probation file. I just have to warn you because my incident date is February of this year.
I understand. And with that being stated, with the probation hearing, if it is a violation, how would that then result for me?
That judge will figure
That's
it out.
on that file. It's not going to change my file at all.
Judge, if Judge, I apologize for interjecting. If you don't mind, can I speak to Ms. McLean again? Because I explained some of these things and I obviously didn't do a good enough job, sir.
Yeah. And based on what she's telling me, it might not be a problem, but I just
I don't think it is either, Judge, but I simply want to clear that,
All right.
Thank
Take her
you.
back in the breakout room.
All right, I'll put you back in.
Yeah.
I'll go out with Miss Magenta. And,
Yeah. Ms. McGoldrick, come on up to the podium for me. You're here today for a dangerous dog misdemeanor from August 5, 2024. The prosecutor wants me to dismiss that. I'm assuming that's all right with you. Okay. That's the good news. Unfortunately, the bad news is you owe us money on some other stuff. So let's see if we can talk about that.
I did some emailing.
Are there any other files there? Hold on, ma'am. Hold on. Are there any other files with her name on them?
I can look. I looked earlier.
Judge, what's the last name, please?
First name Cynthia, last name McGoldrick.
MCG.
MCG. Looks like she's got 4 or 5 files in warrant status, but they didn't send the files in.
4 or 5 warrants?
Yeah, there's no other files for it again.
All right, so I've got a 2019 Van Buren Animal at Large, 2019 Van Buren, I'm not even sure what that stands for, something with an animal charge. 2 charges, Van Buren 2021, unlicensed domestic animal in violation of technical requirements, and all those are in warrant status with money due. All told, because not only those, we've got some other files that you owe us money on. All told, you owe us over $2,000.
Ouch.
Okay. Since when? Because as of April 7th, we've got no record of any payments.
I already made about 3 payments of $200.
When?
The 10th of each month.
10th of each month?
Okay, so my records don't reflect that. You sure it's not some other file? Okay. So how much are you making?
I make
No, payments, how many?
$200 a month. I think I've made 2 or 3. And I know I started off with the $50 one that you have to do to get into the payment plan.
And when's the last one?
I just made one.
Like today?
Like 3 days ago, 4 days ago or something, just to make sure it was before the 10th, sometime before the 10th. I never got something that said what my payment plan was going to be.
The only way that happens is if you come in here and make the payment plan and ask for paper to leave. So here's what I'm gonna do. Today's file is dismissed. Go downstairs, make sure they have record of the payments you think you made, and get your plan when you walk out, you have paper.
Yeah, I'll send it.
All right, go downstairs. You're welcome. Morning, counsel.
I'm ready, Judge. Thank you.
All right.
Bring back Veruca salts.
Well, I was saying good morning to you, but Mr. Graziani's online too. There's Miss McLean coming back in.
I'm here, Judge.
All right, are we ready for sentencing on today's file?
Yes, sir.
Okay, so I'm going to delay sentence for 12 months, which means no further problems today, from today forward. I'm also specifically ordering no contact with your grandmother. Am I pronouncing your last name correctly? Ivy?
Yes, sir.
Okay, so no contact. No phone calls, no social media contact, no emails, none of that stuff. No contact. Understood?
Yes, sir. Yes, sir.
All right. Court costs are assessed in the amount of $300. Can you pay that online today, or do you need some time?
You want me to pay $300 for restitution?
Not restitution, court costs.
No, not today. We'll do a
Tell me how
payment
much time you
plan.
need.
I just paid $1,000 for restitution, so give me a minute. I do have to pay rent and utilities here in
Within
Texas.
30 days?
Give me 60. It'll be paid in full though.
Thank you,
All right.
Judge. Thank you.
So we're not gonna send you anything on that. I'm just telling you, you owe $300. I'm giving you 60 days to take care of it.
That's a fair deal. Thank you, Your
Okay,
Honor.
so you don't get any reminders from us.
Yes,
Fair
sir.
dinkum.
Okay.
Thank you, sir.
That takes care of it, Mr. Graziani?
Yes, Judge. Thank you so much.
No, I
Thank you
know.
very much.
She's paid like $550. The first time, just like she said, I paid $50 for the fee.
Right.
They didn't remove no warrants.
Okay.
She's paid a $200 payment in March, and then she made the $300 payment.
Who's working the cash register today, do you know?
Don't even know.
I saw Grace girl up there.
Why don't you have Jamie walk that file down and hand it to cashier and say Heather's got it online, that she's paid $550, even though that paperwork doesn't reflect it. What do you got?
Just adjourn, civil infractions.
Did you piss off?
Jeremy.
How are you? Good. How's business?
I'm real slow, but that's okay.
Yeah.
It's a roll.
Yeah, you're at the point where slow's okay. Yeah. Yeah. Yeah, just enough to keep your mind sharp.
Want to, I don't plan to head, this way, but I never have.
Right.
And it's all worked out.
Right. You're not gonna change now. Yeah.
Until I have.
Yeah. Well, I was talking to a guy last week, and I said, I'm going to retire from this job, but I'm going to keep working. And that's the nice thing about that bar card, right? If you want to work 3 hours a week, you can find a job to work 3 hours a week. I'm just not wired that way to just stop, right? Like I said, it give you a reason to get dressed in the morning, get out of the house, exercise your head a little bit. No, I think that's one of the greatest things about our profession is you can work as little as you want or as much as you want. Yeah.
They focus on making that big. I'm not one of them.
Yeah.
I want to enjoy the game.
Yeah.
Do you want the 8:15 again for May?
Sure, but one day.
May.
You muted us, Judge. Well, he shoots the breeze with our baby blue lawyer. We're going to fast forward this. Let him hit the button again. Let baby blue go. He's super excited. Show us your best cheer, Mr. Blue Lawyer. Like if your team just scored, what would your reaction be? Yay! Well, that's pretty good. All right. Can't believe it. They finally scored. Let's let them finish their little conversation. Let's see, who's next? Judge says, no, we're still muted. Don't worry about it.
It's just a furlough.
Let's back up here.
Get photos.
Okay. Here we go. Now hit your mute button.
Get photos.
When did he hit it?
January 12th, hearing date.
Right now. It just takes forever to turn on. Five, 4, 3, 2.
Judge, you're muted. I don't know if you can hear me.
I unmuted. Go ahead.
There was a
Thank you.
January 12th hearing date that was rescheduled. Ms. Rayburn's did not appear at that hearing. The underlying citation, Your Honor, there was a pergola gazebo type structure that's in the picture that we just get for our motion that was being constructed on her property. the building official in place of stop work order on that, to get photos, of that stop work order that's posted on the property. Those are the exhibit 3.
Excuse me, is that attached to the house? It looks like it's attached, but I can't tell.
It's just very close to the fence line. It's
Okay.
Structure is that the Ayden Township's accessory structure ordinance provides that accessory structures like this have to be a certain distance.
Setbacks. Okay.
So that's why the stop work order is issued. And if you look at the photographs that we provided, that show a couple of different days that are outlined in the motion, the construction on the property continued.
Mm-hmm.
And there wasn't contact from Mr. Jeff in terms of compliance. And then we'll continue work after the stop work order. And so based upon that, and in default, we're asking the court for an order today to remove the structure from the property.
Okay. All right. Ma'am, you did not file a written response, correct? Okay. So I don't have to look for a document I haven't seen. Go ahead. This is your chance to respond to that motion.
So when we have received to get on our door for the stop work order, my husband had called down to the township office to speak with somebody. Called a couple times, and we keep getting the receptionist. I'm not really quite sure her name. Conversation. We could never get a hold of the ordinance officer. He explained to the woman on the phone that it's just a pergola, it's not a permanent structure, it's illegal. They said everything was fine, it's just a pergola. It's like the ones you buy from Costco or whatever. The only thing done after we received that was on the door was put a string of lights around the bedroom. Other than that, it has not been touched since.
I'm not following the story at all. Based on the judge's face, neither
Ms.
is he.
Manarino.
Your Honor, it's my understanding that when part of the dispute between Ms. Braeburnt's husband and the township was that they didn't believe that there was a building permit required. There's not a permit required, but you do have to still comply with the setbacks. The setback for that is 5 feet. If it's not a permanent structure, as she's saying, then I'm just not sure why we didn't put that 5 feet or attend any of the court dates or do anything official other than this alleged conversation where someone apparently told them it was fine. It's not fine. I wouldn't be here.
Right.
If it was in compliance. We wouldn't have issued a citation and go through all of this if it was in compliance. It's simply not in compliance, and the structure does need to be removed.
Do you have anybody from the building department here today?
I don't.
Okay. So what I'm inclined to do is give 30 days to get it in compliance. If 30 days enough time for them to set up some meeting with the building department to find out exactly what those options are to comply. So if they can move it, if the department's okay with them moving it, then they don't have to remove, tear it down. You understand that? So what are the chances of you getting a hold of somebody so we can set up an appointment before she leaves today? Can you get a hold of somebody on the phone? All right, so here's what I'm going to do. I'm going to order compliance within 30 days. Compliance could be tear the whole doggone thing down, or it could mean move it to give them the setback requirements they're after. Understood? But I'm going to give you 30 days. If she comes back in here, or the two of you come back in here and say, all right, the first time we can get our schedule together is 3 weeks from now, then I'll give you more than 30 days. Understood? So let's find out how soon we can get that together, and we'll actually give a date for compliance. All right? So just go on out, get your calendar ready. All right? We'll come up with a date where you can get together with the building department or your husband or whoever has to get involved. You're welcome.
I'm going to bring in Clarence Allen in 1 second. I'm going to look him up. That was Mr. Bowditch's case that he's only an hour and a half late.
What do we do with it? Adjourn it?
No, we defaulted or warned because he wasn't here. So
is that a misdemeanor?
It is.
Well, we
so
can
tell him to sit on hold till Mr. Bowditch gets here and he can handle it.
That's what I would do. Yeah.
Okay. Thanks.
You got the file? I'll come get it.
I don't.
Go downstairs, or is it out here?
I don't know what we did with it. You just called then I might have it actually. Yes.
He gone.
I'll look on the desk out here. Your desk.
Yes.
Yeah, it's right on top. I got it.
Nope, he's back. We were going to fast forward, but he's got the file. You coming back in? No, maybe. He's making a call.
Hey, did Jeff Bowditch show up yet? Would you do me a favor? Tell him that his client, Alan, that was supposed to be on Zoom this morning, has finally showed up. So whenever Jeff wants to put him into the mix, we'll try to take care of him too, but Alan. Yep.
Okay.
Hi, Mr. Allen.
Boom, boom, boom. In walks Mr. Allen.
Dave, if you keep walking back here, I have that paperwork for you. I'm sorry.
Okay.
Mr. Allen,
Yes.
you're a little late. Do you have a camera?
Yeah, let me figure it out. All right, there we go.
All right. Let me see. You're at 9156 Walnut Street in Pittsburgh. Alrighty. We're waiting for you. Your attorney was already on for over an hour and we let him go. So we're going to see about trying to get him back on. Alrighty.
All right.
So just sit tight.
Thanks for showing up for court.
Thank you.
Yep.
He's in a car. He's waiting. Let's see if they get somebody here. Waiting for the judge. Judge comes back in here.
All right, I'd like to agree this one.
Let me see if I can get the judge.
All right.
I'm going to shrink down a little bit so you can see the judge because I took over his desk space.
He's done.
I have no idea. Those are not on down. Like, I don't see them, because they're few cases, so I just
Yeah.
feel like they're here. But the dad is here.
You can just get for rain, just rain.
Yeah.
Senator, something nearby, great.
Okay, that's fine. That's fine.
Just waiting for the judge still.
Not be rain.
That's all right. You want the file? Yeah.
Mr. Carter, I was thinking if they're juvenile arraignments, I could just get them in and get them out. Because Mr. Greco doesn't have any information yet.
Hold on. You know what Carter's charge is?
Carter's was a misdemeanor, and that's one that you gave to Dave. Dave has that file.
Mr. Greco's got that file, Jeff.
Okay.
I just gave him the Carter file.
I'll talk to them in a minute.
All right.
I just want to get Mr. Houston out.
Go pre-try him. We're not just arraigning him. Today's the date to do something.
Okay.
Yeah, so talk to Mr. Greco about Mr. Hughes. Did you get a date already? Awesome. Oh, can't beat that. 9 a.m. tomorrow, ma'am? All right, so the order will reflect that you've got 30 days to bring it into compliance, however you work that out with the township.
This judge is always just a mess in his courtroom.
Also, well, let me make the change on the order.
Do you have the order for the cleanup or do you need?
I've got an order to show cause. I don't think. Okay, and go ahead and put the 30 days in. All right. Yeah, Miss Bray Burns, I've got records here that you owe us money on some other files. Yeah, please. There's money on this file, and then we've got a 2026 Van Buren equipment violation ticket. So $230 on today's file, and then $240 on the equipment violation ticket. So a total of $470. Yeah, all I can tell you is the ticket was issued by Van Buren sometime this year. And it was defaulted on February 10th, so it was probably towards the middle of January, end of January, the ticket was issued. That would have been a civil infraction, defective equipment, like, you're driving down the road and your headlights are out or something. All right. Are you in a situation to make arrangements on that $470? Can you set up some kind of regular payment plan and get that taken care of? You want to make a commitment now? You want to talk to your husband? What do you want to do?
Not make a commitment right now.
All right. Can you make Can you maybe make a phone call and get a plan so when you walk out of here today, we know what we're doing? Okay, I'm just going to tell, on my paper, I'm just going to tell them you're going to be downstairs to set something up. Any questions? Have a great day. Good luck tomorrow with your meeting. All right, Jamie.
Mr. Allen, I'm going to put you in a breakout room. Just waiting for Mr. Bowditch to jump on, okay?
All right.
Thank you.
Okay, we'll give them a breakout room, give them a moment alone to discuss what they want to do with the case. Yeah, we're waiting for the judge. That's not him. Yes, it is.
That's dismissed. They're both dismissals? Yes. Well, hold on, we may not need the judge. Okay, just want to make sure it's done. How you doing, Heather?
Alrighty, how are you?
So thank you for everything. I really appreciate it.
Oh, yeah, you're welcome.
This guy's going to do the judge's work. Guess he can dismiss stuff without the judge here. All right.
Okay.
Judge is kicking back in his office. Now, someone else comes in to do his work. He keeps kicking back in his office. That's Mom's. Was there another package?
Nope.
Okay, here we go.
It's actually doing pretty good.
I love this judge with the soft sits.
Glad he's here.
Best ever.
Juveniles.
Still not back. This guy looks too much like the judge in my little window.
Mom, you can come with it.
Here we go. Now we're live.
You're on the phone, Rick.
Oops. Wait. How'd we were live just for a second and then. That's not it. That's not it. We lost him. He was there and then he was gone. We're not watching Little Girl Taken Trial, by the way. That's a hard no. So.
And are you Mr. Ojeda?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ojeda, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We did.
State, are you proceeding on the indictment as presented?
Yes, sir.
Mr. Ojeda, you're charged with burglary of a building. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. The range of punishment for a burglary of a building is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe that he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Ojeda, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 18 months in the state jail facility. There's an $800 fine and no applications. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there being such motions.
No, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No country.
State any evidence?
Yes, Your Honor, state up the states exhibit 1 in all attachments.
No objections.
Next state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
She's got that memorized. That's not a reading. That's years of experience. Breaking into a building. Always got the purple cuffs on. Judge just got to the good part. It's a long story. Very verbose officer wrote this report, obviously.
All right, after viewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Other than just call the plea bargain, please.
All right, the court is going to sentence you to 18 months in the state jail facility, give you credit for any time served. There's an $800 fine. Time and money will run concurrently. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Stop stealing.
Thank you, ma'am. And
Stop.
You too. Have a great one. And stop stealing, okay?
Stop stealing, okay? We need that soundbite.
Yes.
Have a great one. And stop stealing, okay?
Page 4,
I'm going to rewind that just a bit so we can get
Alfred Areola.
that. What a name. Back up.
You too. Have a great one. And stop stealing, okay?
There we go.
Have results on this case.
Mhm.
So if we could have another setting for a plea deadline, I guess.
All right, and you need to make sure you're in time for court.
Yes, ma'am.
So, how much time are you requesting for a plea deadline date?
30 days, maybe.
All right, Norm, I need a 30-day reset for a plea deadline date.
Yes, ma'am. That'd be May 14th.
All right, that's your plea deadline date. Once you sign the reset form, you are excused.
Thank you, Judge.
You're welcome. You're welcome. Have a good one.
I do apologize for being.
Stop stealing,
All right,
okay?
just make sure you're on time next time, okay?
Yes, ma'am.
Love that. Stop stealing. So cheery. Thurston is working right now, but I'm not sure what's going on.
All right, so Ariella, other than page 4, do you see what
do you
other
think-
page he's on?
Sorry, I missed this big guy. What do you think Judge Boyd will do
Okay.
after her term is up?
The bottom, Judge.
All right, thank you.
I don't know. I'd like to see her nominated for the Supreme Court in the state of Texas. That would be cool.
All right, thank you.
Also, wouldn't mind seeing her doing something more in the public, in social media. Do a commentator. It would be great if she became like a court watcher in the case in the court with the woman that took her job and filed all the documents and just televised every single one of her cases just to spite her. She's not petty like that, but that would be funny. Let's see.
Yes.
So I have a 5-month-old baby, so I'm still pumping. So I don't know when I can.
Oh, no, go ahead.
Do that.
Yeah, sure.
Okay, I'll be back.
You can take a break till, we'll be back in the afternoon. Sure.
Congrats on the child.
All right, Norma, we're going on recess.
Yay, recess. Oh no, not that kind. All right, let's go check out.
Attorneys are to be back.
Let's go check out Thurston County then.
Gotta wait here.
Who's in?
And Your Honor, whenever, if the court is busy, we're not in any rush, I don't think, to get this entered. So whenever the court is able to is fine.
It looks like May 13th, we can do it without overloading another calendar. So let's do that. And then any change to your client's contact information?
No, Your Honor.
Let's skip ahead and see what they're doing if they're still alive.
So I would ask that terminology be allowed.
Well, the issue is in the special verdict form, having to determine if they're intimate partners is how you wrote those. And yeah, and that's has to be proved and determined from the jury. And then, all right, so in that.
Are these motions in limine?
Okay, so Ms. Groth, is to 12.
Yes, Your Honor. In terms of the jury forms, I would not object to them being in the jury forms as it is a part of the case being tagged as domestic violence. I would just say limiting as much as we can the use of the phrase domestic violence for potential prejudice issues to the jury.
And I don't think it'll come up in this case in terms of the exact words, but I just would, if it happens to come up from one of our law enforcement, I don't want it to be.
Well, I think jurors are pretty sophisticated anymore, given this is front page news for decades now and far more prevalent now. Just even the last couple of days with folks at federal level and state level. So it's not a phrase I think that would carry, and I don't find that it would carry anything unfairly prejudicial to your client. Obviously, and I'm with you, Ms. Groth, that if it kind of becomes a harrying cry, which I'm not hearing that the intention is from the state, but if it does, I'm going to make a different decision there. But so in that way, I'm not granting your number 12, but you've heard me reserve it if it becomes this cry from the state, which I don't think. And then 13, Ms. Pritikin.
We're going to jump to
similarly,
the other Thurston court.
Tyann Bredesen.
What time is it on?
Your Honor, is at 9 a.m.
What was the last name again?
Bredeson. B as in
okay,
Bravo.
Yeah. Ms. Eddy. Is that person here or no?
He is not, Your Honor. I thought he was in compliance, so I told him he doesn't have to be here per court order as well.
Ms. Eddy.
Yes, Your Honor. It took me a second to catch the name. If I could just have a second to pull that up.
Thank you, Your Honor. Yep, sorry again for being so late.
Yes, Your Honor. the city would move to dismiss the defendant is in compliance.
All right, that'll be dismissed then, Mr. Sue. Do you have any others?
That's all I have. Thank you so much, Your Honor. May I be excused?
Yes, of course. Again,
Thank you, Your Honor. Thank you, counsel.
apologize to everybody, but sorry for making you wait around forever all morning for that.
It was worth the wait.
Mr. Irinella?
Yes, good morning, Your Honor.
Hi there.
I'm here for one
Yeah, case-
matter.
Okay. And is that Sheila Mwendwa?
Yes, it is. She's
What's happening
online.
today?
Yes, it is. She's online via Zoom.
Okay. What is happening today with that there, Mr. Irinella?
So for this matter, I looked at the JAS review issue. It was for treatment compliance. The treatment compliance was already addressed at the last hearing for a different case number at 3A0845329. That's the subsequent DUI case in which my client entered deferred prosecution. And the counselor actually appeared by Zoom and testified.
Right. It looks to me like she's in compliance with her deferred prosecution.
Yes. That's kind
So,
of
I mean, I think the issue is a predisposition case, which is DWLS in the third, and operating a motor vehicle without ignition interlock. I guess that's where we headed with that. And so that could be a violation upon conviction, of course. And so, but I don't, at this point, it looks to me, again, I'll double check.
So she has the new matter scheduled for tomorrow, along with another review for the deferred prosecution tomorrow.
Okay, so what do you want to have happen today?
We're just requesting a continuance of the review for this case.
Well, this is a pretrial. Like I say, we don't need, you don't need to worry about the pre-FTC. I mean, if the pretrial on the predisposition case, that's what I'm asking, what you want to have happen with that.
For our case today?
Yeah, there's two cases on here. There's a pretrial case and a post-disposition case, right? The pretrial is the DWLS in the third, operating a motor vehicle without an ignition interlock. And so there's that. And that's right now it's set for trial. And I can tell you when that trial date is in just a moment. That's all right. It's all right, Erica. It's all right. Thank you.
So
May
for the-
18th at 9:05. So hang on, let me finish, right? So there's that. And then on the post-disposition case, the DUI, you'd reference the treatment issue that's on for review for pre-FTC. Looks like she's in compliance with treatment now, unless she's not. It looks
Your Honor, the city disagrees. My notes, I believe, reflect that that the defendant was terminated in October and was.
Well, I have look at maybe it hasn't made it into the file then, because on the DUI, the state case, the deferred prosecution, she was in compliance for as recently as March 2026. So she's on a program of deferred prosecution on a state case, right? And I have compliance reports for that. So I'm assuming, and it made it into the state file, but apparently not the Lacey file. So it looks to me like she's currently in treatment. Ma'am, are you currently in treatment? Yes. And where are you at the right spot?
Yes,
and
sir.
so I think the issue there is, so I look at that to think that she's going to be in compliance, but apparently it hasn't made it into Lacey yet. And so now what I want to try and find out is there a plan in place with this DWLS on the third ignition interlock, and what, if any, impact would that have on either the pre-FTC, that is a violation on the pre-FTC and the DUI, but more importantly, it may affect the deferred prosecution. I don't know the answer to that. My question to you, Mr. Irinella, is how you want to handle these today. And before you answer that, Ms. Could you adjust your camera, because all I can see is the top of your head. There you go. May adjust it a little bit more, please.
Sorry, I was just writing down.
Thank you. Okay. And ma'am, you need to talk to your treatment provider because you have 2 DUI cases here down in Thurston County District Court. And as far as I can tell, your treatment reports are only going to one. They need to go to both cases. Do you understand that?
Okay, I know they're going to Thurston.
Yes, they are. They're going to
Probation.
Thurston, but Thurston also handles Lacey municipal cases. This is a Lacey case. The Thurston case, yes, we're getting them. And that was the confusion, I think, on the part of the Lacey prosecutor. She didn't see that. But I did, because I looked in the case, it's not on the calendar today. I looked on your state case and saw that you are in compliance. So
Okay.
Mr. Arenella, I'm going to come back to you. What do you want to have happen here today?
So for the case number set for pretrial 680, that case number, I'm just making a motion to strike because she does have a hearing scheduled for 5/18. And I know
Okay. We can just leave we can leave that date set, and then this pre-FTC you'll track with it. And then tomorrow you have a review on the state case. We'll just let that go. But let me hear from the city of Lacey. Does the city of Lacey have any objection to that course of action?
No, Your Honor.
Okay. All right, ma'am. So you need to consult with your attorney. Mr. O'Neill needs to talk to a couple of people, both the city of Lacey and the state prosecutor, to see what may happen on all of this. Do you understand that, ma'am?
Yes, sir. Yes.
And you have a court date tomorrow, apparently. So we'll see you here tomorrow here also. All right.
Alrighty. Thank you so much.
May I ask, Your Honor, if someone changes treatment programs, is it this jurisdiction does the court require the second provider to look at the first provider's evaluation?
Typically, yeah. But I mean, if she's on a deferred prosecution, which is a more stringent program, then yes, typically. But you can, yes, and certainly everybody should talk to each other, both the city and Lacey and Mr. Arenella. So the city knows what the program, city of Lacey knows what program she's doing for the state, and whether that will or won't comply with, yeah. I hope I'm making myself clear.
Understood, Your Honor.
But something tells me I don't think I am. Anything further with you, Mr. Arenella or Ms. Wenda?
No.
All right, that's it for today then. You both are free to go.
Thank you.
Thank you.
You're welcome. And then attorney, is it
Lacey Washington?
Manigbas? Could you come on the Zoom call, please?
Good morning, Your Honor.
Hi there.
I'm here on
And then
Mr.
you-
Andrew Boudias, Your Honor. He should be present.
Is that
in the
you,
courtroom.
sir? He is. I think he is anyway. Yeah, you could take a seat there. So what's happening this morning with Mr. Boudias?
Your Honor, we're requesting to continue this matter about 30 days. We're still trying to negotiate with the state and hasn't had any progress with that yet.
Well, it's the city. So
Correct.
maybe you can start. And so, all right, well, right now there's a confirmation date set for May 4th. We'll just leave that court date set, give you and the city a chance to talk before then. We'll reconvene on May 4th and see where we're at.
Understood, Your Honor.
You may go.
Thank you.
Have you been getting text reminders of court dates?
I am indeed.
Perfect. You may go.
Thank you.
And that's it for today there, Mr. Manningbos.
Thank you, Your Honor.
I'll apologize to you as well for making you wait around for all of that.
No need, Your Honor.
Is Mr. Nemec or someone here on his behalf? Is that, come on up. You're here for confirmation. And that is it, Mr. Amali. Am I saying your name correctly?
Yes, Your Honor.
And then what's happening today there?
And Your Honor, we are entering an associated
Sure,
approach.
bring it on up.
Thank you.
You're welcome. And you are Oberton Amali?
Yes, Your Honor.
Am I saying that correctly?
Yes, Your Honor.
Looks like you're here on the charge of theft, or I'm sorry, malicious mischief. And so I'm looking at what's known as a stipulated order of continuance, which tells me that you and the city have agreed to continue this matter for a period of 2 years without a finding to dismissal, so long as you comply with the following recommendations. Don't consume any alcohol or have any controlled substances out of valid prescription. Don't refuse a breath test. Stay out of bars and taverns. Don't have any new law violations. Don't possess a firearm or other deadly weapon. Get a drug and alcohol evaluation. Comply whatever is recommended. Do you understand all those things?
Yes, Your Honor.
Do you understand if you do all those things at the end of 24 months, this will be dismissed?
Yes, Your Honor.
Do you understand if you fail in any of those conditions, though, you'll be brought back before the court and your guilt or innocence will be determined by reading of the police report? Do you understand that?
Yes, Your Honor.
So what's happening is you're giving up your right to a trial. You're giving up all other rights associated with this, but what you're getting is the opportunity to have this dismissed so long as you comply with those conditions. Do you understand that?
Yes, Your Honor.
And I also should mention, apparently restitution is reserved, so there may be a restitution issue. Does the city think that there will be, or is that, do you have any idea?
Yes, Your Honor. He broke the victim's phone and car key, so we.
Okay, so anyway, that may be an issue at this point. All right. Did you review this entire document with your attorney there, Mr. Nemec?
Yes, Your Honor.
Do you have any questions at all about what's happening?
No, Your Honor.
Have you done your evaluation yet?
He has, Your Honor.
Okay, and what does that say?
No significant problem. I do have a copy, Your Honor.
Okay, great. Did he do the class? Did they require the drug and alcohol information school?
No, they did not require.
Okay. Yes. Ms. Eddie, do you want to say something?
I have a copy, Your Honor.
Okay, great. Thank you. All right. Anything further from the city?
Just the only thing I didn't hear the court mention was the $240 monitoring fee.
Okay. That since he's completed his affirmative, well, yeah. Okay, go ahead. Anything further?
No.
Mr. Nemec, anything you'd like to say at this time?
And Your Honor, I did review this with Mr. Amali. I do believe he's entering it knowingly, intelligently, and voluntarily.
Mr. Molly, anything you'd like to say at this time?
No,
you
Your
don't
Honor.
have to. You have the right to address the court. You don't have to if you don't want to. But anything you'd like to say?
No, Your Honor.
City, have any objection to, since all affirmatives have been completed, to just be monitoring for record checks? Any objection? And this is a contract between.
I don't
any
mind
objection to-
changing it to $120. That's the amount if there's no
Yeah.
active requirements.
And so, Mr. Amali, this will be continued for a period of 24 months to dismissal. Don't have any criminal law violations. Don't consume any alcohol. Don't refuse a breath test if one is requested of you. Don't possess a firearm or other deadly weapons. Stay out of all bars and taverns. You're going to be on what's known as monitored probation, which means you're not going to have to check in. They're just going to run periodic record checks to make sure the one affirmative requirement that you've already completed. So, they're not going to be checking for anything like that. They're just going to be making sure there's no other law violations. And there will be $120 monitoring fee. You need to pay that. And then if that gets paid, no other problems, this will get dismissed in 24 months. I am going to indicate that the restitution is reserved, which may or may not become an issue, but I'm sure your attorney will let you know if that comes up. Good luck going forward. We'll print a copy of this for you in just a moment. Once you get that, you're free to go.
Thank you, Your Honor.
You're welcome.
Your Honor.
And again, I apologize to everybody else. I may as well apologize to you too. Sorry for making you wait around all morning for that.
No apology necessary, Your Honor.
This judge flies through the criminal cases and drags his feet when he gets to the civil cases. He hates them. That said, Thurston has some of the funniest civil cases I've ever seen.
Ms. Langley, you want, go ahead. We can pick up yours and then we can work with.
Ms. Langley, you're on mute.
Thank you. You're muted there, Ms. Langley.
There we go. Thank you. Okay, I guess I'll just start at the top. Sarah Anderson on the 8:30.
And then is she here?
She's on Zoom.
Can you come on the calendar there, come on your camera, Ms. Anderson, activate your microphone.
Good morning, Your Honor.
Hi there. What's happening today, Ms. Langley?
This is a review, but it looks to me like there's updated compliance reports in the file. One of them having been filed today. Looks like she's in compliance.
Ms. Eddie?
Your Honor, I haven't reviewed anything. I haven't received anything for today yet that I've had a chance to review. So my notes say that we previously did a motion to revoke because the victim impact panel wasn't filed by February 27th as ordered by Judge Wilcox. And then there was a positive UA on January 29th for cannabis.
Did you file something today? Ms. Langley, did you say
No,
something
I saw in the docket that something was filed, and I just checked the court files. I just saw the last two reports on deferred prosecution that she was in compliance. So that's as much as I know. I guess I missed the part about the victim panel, so I don't know if she's done that or not.
Well, we can ask her. There is a compliance report that was filed on April 9th, which says she's in compliance. Incident report on February 6th, relapse. Okay. There was an incident report on February. Is that what you're referencing?
I'm referring to a positive UA for
Yeah,
cannabis.
that's right. THC on January 29th. It was filed in February. It looks like she's back in compliance. There's compliance reports for. She was trial transferred to a higher level of care. And now she remains in compliance. With regard to the victim's impact panel, where are you on the victim's impact panel, ma'am?
Yes, it was. I completed it January 4th of 2025 through the city of Olympia. I can get proof of that. I know that it's been submitted in another case in another county, so I apologize that I haven't. When I call the number now, it directs me back to Thurston County District Court.
Where do we get those? Do you have a City of Olympia case?
No, that's just where I found a victim impact panel to do, was through the city of Olympia.
So
I think she has a active
I
case.
understand what's happening. But the victims impact panel, I think, are run by not by the court, or were they run by probation? Do you remember? Well,
the lady's name that led it was named Michelle.
Okay, so ma'am, just she doesn't work there anymore. Okay, all the City of Olympia has been transferred to Thurston County District. So a lot of the probation staff back then aren't with the court now. So, but I don't know whether we have those records or not. All of them, all the active cases came over, but whether they have records of. So what's going to happen today, ma'am, is I'll find you're in compliance with regard to your treatment program. We're going to reset this about a month. And then you can, or Ms. Langley maybe can go back to the city of to the probation department here and see if they can access records for victims impact panels that have been done a while ago. That's the only thing that can happen.
The other possibility, Your Honor, is it may have been filed with Pierce County where she has an active case. So I can also look into that.
Yeah, that'd be great. If you could get a copy of it from there, that would work.
Okay,
Ms.
Your Honor.
What's the city's position on where we go from here in that regard? The positive ULA looks like it was dealt with in treatment. There's a follow-up report.
I'm satisfied with the court's finding in regards that she's in treatment. I still would like to see the proof of the victim impact.
That's why we're resetting it. Okay, so we're not just going to strike it. So we'll go out about maybe 5 weeks. And you, Ms. Langley, to tell you the truth, and you, Ms. Anderson, you might have better luck going to Pierce County, see if you could get a copy of it out of that Pierce County file, frankly. So we're we remain in a period of transition around here.
I understand, Your Honor. I'll be in touch with Pierce County.
What's that, Erica? You sure? Say it again, please.
State of flux.
May 11th at 8:30 will be your next court date. And good luck. Continued good luck in your treatment there.
It's gonna be May.
You may go, ma'am.
Boop. She's gone.
Ms. Langley, who's next?
Jessica Hankins.
She on the Zoom call?
She is.
Can you come on the Zoom call, ma'am? What's happening today, Ms. Langley?
Ms. Langley, you're muted again.
I'm sorry, Ms. Langley, I couldn't hear you.
Let's leave the date set.
Okay. So Ms. Hankins, have you been getting text reminders of court dates?
Yes, I have, Your Honor.
Okay, so your next court date, thank you for being here this morning. Your next court date's going to be, I'll tell you.
Scroll, scroll, scroll. May 11th.
Your next court date is May 18th. So we'll see you back here on that date, okay?
Yeah, what time is that?
That
It's 9:30?
is 9:30. Yes, ma'am.
And I can appear on Zoom again?
You can.
Okay.
Make sure you maintain contact with your attorney there so you have a plan in place for when you're back here.
Okay, thank you, Your Honor.
You're free to go, ma'am.
I have a plan in place that involves going to lunch.
You're welcome. Ms. Langley?
But I don't have a
plowing
plan in
through.
place for this
Okay,
afternoon.
Rodriguez. Anel. She's on Zoom.
Got it. She's here with Ms. Rodriguez. I see you there. What's happening today, Ms. Langley?
Just let's leave date set. We're still talking.
Okay. Looks like your next court date is May 18th also at 9:30, ma'am. Have you been getting text reminders of court dates?
Yes.
Okay. That's it for today. We'll see you back here on May 18th. Make sure you maintain contact with your attorney there so you have a plan in place when you're back here on that date.
Okay, thank you.
You're free to go.
Okay.
All right. Red says, did you get the 4K kit working? Yes, I got all the Ethernet and everything working. I've got 5 more video connectors to put on the back of the box, which are arriving today, and cables. And once that's done, it'll be all bundled up and ready to go. So it's all working. I can do all the only piece I don't have yet is the ability to bring like your phone, Red, or whoever else is if you're outside a courtroom and you're like, hey, this is what's going on outside the courthouse in my area. The ability to bring that video in on a live stream. I don't have that piece yet. That's one more purchase, but it's in my shopping cart, so it's probably going to be purchased soon, and then we'll be able to bring court reporters, people from the scene of something happening, right into our live stream from anywhere as long as they have internet connection. So through their phone. All right, take it out to the park and give it a test stream for us. I was running a test this morning before we went live on battery power. I can run it for 6 hours on my existing battery backup, all the equipment. So one more screw streaming, yes, or a stream of screwing things together. I also need to run to the hardware store probably on lunch and find a socket that fits that little tiny nut because, man, my fingers hurt so bad from trying to hold that thing. I volunteered to be the first test subject on my phone on the app. Okay, I'll give you the link. Well, I can't give you the link until I have the box. So I need to get the box first. Go to a park, get your ham radio out, and see how many states and countries you can get. That's POTA, Parks on the Air. I don't have, well, I'm only a technician, no code, when it comes to ham radio. So I can't really use the bands that are able to jump continents and stuff. Don't do any long distance stuff. I've always just been like a 2 meter, 70 centimeter bands guy. So those two bands on walkie talkies. All right, that's all. That's our next project. It's been a slow day. It's been a very slow day. It's 1:30. It's definitely lunchtime. I'm not positive if we're coming back or not. I don't know. But if we do come back, then we'll be here. And if not, we'll see you tomorrow. Does that work? We're working on getting another big case comes up. It's like 2 weeks away for our next big case. We'll see if we can find something else in the meantime. We're not going to do the FedEx trial. That's a no-go. No-go. Tonight, I'm going to go home. Please hug the people you love. Smile at someone. Make their day a little bit better. And please stay safe. We'll go live again tomorrow or soonish. Or soonish after just whenever it is. All right. Thank you all. Thanks for a great mods. Sorry, it's been a slow day with a little court hopping and not a lot of, other than Judge Dad. We didn't get a lot of action this morning. So maybe we'll get some more stuff this afternoon or tomorrow. So you guys are amazing. Purple Coconut says $5. It's tomorrow. Soonish afternoonish. Depends. We do have to go to pick up my car, which I guess they took the whole engine out, fixed it, put it back in. So we have to pick that up today if it's done. So we've got to do that on lunch as well. You guys have a great lunch. We'll see you.